हेलो। वहां पे म्यूट कर दो। हेलो। अभी तो हो गया। हेलो। यस सागी। Dr. Sagi,
Yes.
I believe you can hear me.
Yes, I can.
Okay, you can start the session. Professor Antonio is here, and also Professor Gulliam is also here.
Great. Okay.
The rest of them would be joining shortly.
Okay. All right.
We can start the session.
All right. Thank you so much. Good afternoon, everyone. Good morning for us. Good morning for some of you, maybe. Welcome to, this is the 5th edition of the International Conference on Comparative Law, and we are at the keynote addressed by some of the leading experts. So what you would witness here will be a take on comparative law. Probably the experts on constitutional law would talk on those aspects, and will be enlightened today by their expert rendition of or on constitutional law or comparative law. So we would start off the session with Professor Anthony Abad Inine. I hope I pronounced that correctly. From University Autónoma de Barcelona, Spain. Yes, and he's a professor of, he's an expert in constitutional law and comparative law. Welcome to the session, which will be followed by Professor Guillaume Tissot, again, pardon my pronunciation, Professor of Public Law, Sciences Po Law School, Paris, France. This will be followed by experts from India, Vice Chancellor of National Law School, National Law University, Tripura, Professor Yogesh Pradap Singh, and Vice Chancellor of National Law School, Delhi, National Law University, Delhi, Professor G.S. Bajpai, and Director of Gujarat National Law University, Professor Shantakumar. So we are looking forward to hearing from some of the best expert minds on comparative law. And without any further ado, I think, but briefly, I will have to say that 14 minutes is what is allotted to each of the speakers. And we are all standing between your speaking and the lunch, which, later. So the hunger and hunger for knowledge and hunger in essence will be there. But let's start off with Professor Anthony Abad Inine.
Namaste. Thank you very much for the invitation. It's really an honor and a pleasure to be here, and I really appreciate the possibility to join you in this very well organized and amazing conference. I would like first to ask for some kind of indulgence, because here is 8 a.m. and it's too early. So maybe if I say something that it doesn't make sense, probably it's because of the early time that I'm speaking. So as I said, I really appreciate the invitation, and I hope that to fulfill some of the expectations that Dr. Sagi has already mentioned in the introduction of the conference. It's as I said, a pleasure to join you, and for instance to listen and to participate with Professor Tissot, which is a very well-known name. I don't know if I'm expert is a word which a lot of transcendence is very heavy word, but I've been working with comparative law since I started my career in academia, and also as a professional, because nowadays the same evolution of society force us to talk and to deal with comparative issues. So my conference, I thought it was like 15-20 minutes. Maybe it would be more or less. I don't know. I'm quite unstructured guy. So it's first of all, I would like to mention what means comparative law. This is something that apparently we all share and know. But as I normally do in my lessons and in my faculty, is a kind of analysis of the same word, right? Comparative comes from comparare, in Latin, and comparare has two main terms: com and parare, right? Com means to put two together, and parare all, meaning to face at least two different concepts in the same holistic perspective, and to make this exercise to put one in front of the other, and to check, as I said, as a whole, as a unity, all the domains that we are addressing. So Comparative law as such, it has been always related with the analysis and the study of law. I mean, we can even think about Aristotle compilation of constitutions and the analysis of the Athenians of the different constitutions as political systems, right? As politeia, not as documents, but how they were dealing and analyzing different systems, even with Persians and other constitutions that they were already around the world in a comparative terms, and in order to check and see how with different or similar issues they were dealing and providing different answers from a political at that time perspective. So following with this Greek ancient Greek starting, I also thinking about famous Socrates and thinking about knowing ourselves, right? We need to know ourselves. Knowing ourselves means comparative exercise and comparative law allow us to know ourselves too. So it's a way of reflecting not only in comparative terms, but also is a self-reflection of our legal systems and political domains, structures, etc. Meaning that when I'm introducing my comparative constitutional law courses, what I'm saying to my students is that we're going to learn from all the systems, but we're going to learn a lot about our own system. Not only because lately, I mean, especially in the European Union, we're using a lot of comparative constitutional law in terms of jurisdictions and comparing decisions, comparing textbooks, but also because, as I said, with the same etymology of the word, it shows that we will with this exercise of comparison, we're going to see how our system reacts in front of facts, or how our systems deals with different aspects. So it's inconceivable nowadays to think of a pure non-comparative system around the world in the 21st century. But this has been from a factual point of view the case for a long time. So when I am dealing with comparative constitutional law, what I'm also stressing is this is first, we will know more about all the systems. I also make kind of jokes to my students. This is a way of make a trip, right? So when we are analyzing decisions of the Supreme Court, the never-ending decisions of the Supreme Court of India, so my students, they can transplant and think in that they are dealing with Indian constitutional Supreme Court issues and aspects. Is a way of also to travel, to trip, to know other, to know, even that you stay here in Barcelona, sitting in your class, but to think and to be aware of different systems, and it's a way of traveling. Then as I've been mentioning, this is one, of course, of the benefits from a personal perspective, but also a benefit to understand when we are implementing, as is happening, what we define in academia as constitutional borrowing, right? When we use a different constitutional answer, constitutional prescription, or regulation, and we transplant in our system, we define it as a constitutional borrowing by some authors. This constitutional borrowing has, of course, different, it needs to be coherent with your own system. It cannot be abruptly imposed. And we are appreciating that this constitutional borrowing happens along the different systems. Certainly, it is more, we have more tendencies, and we have historically, not only in constitutional law, but also in our legal systems, to borrow or to implement not only comparative, but also the influences of our neighbor, the same legal genealogies or legal families. For instance, we have here Professor Tussaud. He's from France. In my country, in Spain, we have a very strong French influence in not only in codification of our civil codes in private law, but also in public law too, and the other way around. Because also from Italy, let's say in our structure of the state as a we define it as a state of autonomy, which is a sort of hybrid between a quasi-federal state and regional state. So if you analyze the last century constitutionalism and the structure of the state in Spain, none in the Francoist fascist regime that were ruling the country for 40 years, but before. So we used the regional state, and then Italy in the implementation of the constitution, the current constitution of the Italian Republic. They were influenced by the Spanish experience, and now the constitution of 1978 in my country has been affected by the experience of Italy. But this is very, very general and very broad examples. Other examples are, for instance, when the Conseil constitutionnel français makes a decision on how to deal with the case of Corsica, of other issues in terms of the territorial structure, for instance. It's from the Spanish perspective, we learn of how, or the Quebec, for example, I'm thinking in different scenarios. The decision of Quebec and secession has been extremely important and influencing in constitutional issues around the world, I will say. We have a lot of examples. It comes into my mind, for instance, the concept of human dignity, how it has been implemented in Germany and then in Israel, and other examples. But so I think that comparative constitutional law and comparative law, it's inevitable. I mean, you cannot avoid it. It's something that is happening, and it's going to be even more and more, because nowadays there is less borders between the systems. We have more a global relation and comparative terms and comparative law. It's an indispensable tool for our career and legal domains in constitutional law, but I think that also probably in other legal domains. Say that I want always to emphasize some, let's say, not limits, but cautions that we need to take into account when we are applying comparative law, at least also in constitutional law. One of the main issues that I also stress when I'm dealing with my students with the topics of comparative constitutional law is the concept of legal acculturation. So we need to be very aware, and this is also related what I was saying before. For us in my country, it's very easy, or it's not that difficult to implement legal institutions, legal solutions that happened in France or in Italy, because as I mentioned before, we are of the same legal family, right? So it's more difficult. We have differences, of course, but we have strong similarities. Then we need to be cautious when we are applying some legal institutions or legal decisions or legal frames to our own legal system. We need to be cautious that we cannot do it abruptly. We cannot provoke what we call a legal acculturation, because this is more than a solution. It will be a problem. Also from a legal coherent system, when you are implementing or adopting a legal let's say institution that is implemented in another country, and you think, or the legislator think, that it can be a good solution in your country, you need to adapt to your own casuistry and reality. And this is always taking into account that there's this limit on legal, on not to provoke what we call a legal acculturation, because then you can have pernicious effects in not only legally but also in other systems. And another thing that we need to take into account when we are trying to implement, or we are encouraging the application of comparative solutions on terms in our own systems, is the context. Sometimes, and I think it's the vast majority of cases, context matters, and the application of institution that from a legal perspective, you need to take into account the context and own casuistry of the system that you're learning. Nowadays, the lingua franca is English. For several years was French, and we tend to think that when we're reading decisions of non-English countries, but we are doing in English, we think, or we believe that there is we trust, let's say, the translation of these sources. And sometimes this is very complicated. I'm thinking in Chinese legal systems or in Islamic legal law. when we are dealing with Islamic sources that are translated into English, sometimes translations is also interpretation, or as the Italian says, traduttore, traditore, which means that you cannot really trust 100% these translations of the sources. So the most ideal scenario would be that you have the possibility to read the sources in the language that they are originally made, because some of the concepts and legal aspects that you use, they are not simply applied to your system. I'm thinking, for instance, in a very basic and founding principle of the European Union, the concept of rule of law, which the concept of rule of law in English have we understand we have different decisions also of the European Court of Justice defining what the rule of law means, but in French, and is état de droit in my mother language, is also état de droit, which is very similar. It can be related with one of the exceptions of what rule of law means. But for instance, in German, rule of law, it's Rechtsstaat, but it's also Herrschaft. So what I'm saying is that within a same concept, we can have different interpretations of the we don't need to go very deep in Ferdinand Saussure difference between significant and signifié, but I mean, this is something that we need to take into account when we're promoting comparative analysis and comparative law. I would like to end with two critique, because I'm a critical guy. I mean, I'm doing academia to criticize. Is the only way that I have fun. And one of the main issues that we need to take into account, and I think it's somehow related with the concept of acculturation from one hand, and on the other hand, on the language barrier that we need to take into account, is that we need to take into account to avoid what it has been called as a kind of epistemological colonization. I mean, if we impose a concrete legal institution, legal system, or legal perspective even from a comparative way to a country which is a completely different legal genealogy or legal history, it can be suspicious of what some academicians have called as a legal colonization. So I'm a professor of comparative constitutional law. I'm using comparative law. And I need to be aware that when I'm analyzing a factual reality from a comparative term in China and in Spain or France or Italy or Germany, I need to take into account that my position cannot be simply imposed to the Chinese legal cosmos or universe, because sometimes this has been used as a tool to implement what we call epistemological colonization, and we have several examples. And what I wanted to end is with a question, which is a paradox. I believe it's a paradox, and it's something that we need to reflect, especially in this kind of forum, and which is a very academic and of high level. It's and I think tomorrow, Professor Richard Albert, which is also a close friend of mine, I think he will be talking, and he's I don't know if I can use the word advocating, but he's promoting or he's reflecting the tendency of global constitutionalism. So my question is whether comparative constitutional law is threat by global constitutionalism, right? Unless the global constitution. I hear some noise. Someone. Sorry. Yes. Now I think now the micro. It happens to me always. So and it's good that my daughter is not here, or my cat. So what I was trying to say and to pose is whether the tendency or the academic analyze and which is reflecting the reality of something called as global constitutionalism, it can be a threat of comparative constitutional law in terms of a real comparative terms. Why I'm saying that? Because we are already, I believe, predicting that this main basis of global constitutionalism, as it's called as global, is really related with some concrete legal systems. And if again we have different ways to define what a constitution is. We have different ways to understand what constitutionalism is: Islamic constitutionalism, Native American constitutionalism, Chinese constitutionalism, African constitutionalism. So if Indian constitutionalism probably is also a different, well, I don't know, Indian is very Indian constitutionalism as such. You know better than me, but I mean, maybe it's a different scenario. But in other countries, so if we want to talk about global constitutionalism, we need to compare all these different understandings of constitutionalism, and then all together provide a global definition of what a constitutionalism is, and the institutions that we are defining as global as such. Otherwise, it will be again a sort of imposition, and comparative won't be so comparative, but more impositive. So this is my reflections. I want again to thank you very much for the invitation. It has been really a pleasure, and I really appreciate the time that you provide to me. And I will be now listening to Professor Tuso and the rest of colleagues as far as I can, because then I have another conference. So I really appreciate. Muchas gracias, which means thank you very much in my mother language. Namaste.
Gracias. Gracias, Dr. Anthony. That was, food for thought for everyone to think about and ponder more or work more in this area. I'm sure you've given us a well ground for the students as well as academicians to look into the matter of colonialism, as you mentioned, but we'll come to that later. We are now going to listen to Professor Tuso from France, Professor of Public Law at Sciences Po Law School. Welcome, Professor. Over to you, Professor Tuso.
Thank you, Sergi. It's a real pleasure to be here. Thank you for your invitation to join this awesome conference, and for giving me the opportunity to listen to Anthony and all the other participants. So my talk is about the methodology of comparative law. My first claim is that we need more empiricism, even as lawyers, even as jurists, when we try to study different legal systems, that is, a system or systems in plural that are different from the one in which we were bred as jurists. And in order to substantiate my first claim, the need for more empiricism, I will take one example, the example of a very classical, a very widely used tool in comparative law scholarship, which is the distinction between two main models of judicial review: the European model on the one hand, and the American model of judicial review on the other. The starting point is common to both models. It's the idea that comparative constitutionalism is based on the idea expressed by the Constitution of the United States, but also expressed by many other constitutions, that the Constitution is the supreme law of the land. If constitutional law is to be understood as law properly so called, it needs to be, which means in the framework of our contemporary legal thought, that there needs to be a judge in order to ensure that all the other public authorities, all the citizens respect and abide by the Constitution, understood as the supreme law of the land. That was the basis of John Marshall's reasoning in the famous case Marbury versus Madison. That was the basis of l'Abbé Sieyès' reasoning during the French Revolution. And that was also the reasoning of Hans Kelsen, the founder of the Constitutional Court of Austria. Based on this common starting point, two main strategies seem to have emerged in order to protect the Constitution and to guarantee that it is correctly applied. And this is why, in order to organize the comparison of all the systems of judicial review that currently exist in the world, legal scholarship has divided or identified or invented two main patterns for the organization of constitutional review. The American model has its own idol, John Marshall, of course. The European model has its own icon, Hans Kelsen, of course. The opposition between those two models is based on the opposition of four criteria that, according to dominant scholarship, help identify and distinguish both systems. The American system can be found, according to traditional scholarship, in the United States, of course, in India, in Canada, in Japan, or in Argentina, for example, that is, in very different countries. The European model can be found in France or in Spain, to borrow from what Anthony has said and presented. It can be found in Germany, it can be found in the vast majority of Western European countries, but it can also be found in South Korea, for example. So it's a widely spread across the world. So the American model is based on decentralized judicial review, which means that every judge is empowered to review the validity of statutes. On the contrary, the European model is based on the idea that ordinary judges cannot decide about the validity of statutes, and especially about the constitutionality of statutes. Only a specific constitutional court, constitutional tribunal, or constitutional council, as it is called in France, can do this. So there is a monopoly for a specific ad hoc constitutional review institution. The second criteria to oppose the two models is that judicial review in the American system is concrete. It starts with a case or controversy, that is a concrete litigation between Mr. Smith and Mrs. Jones. Whereas on the contrary, the European constitutional review is abstract, which means that it doesn't pay attention to the concrete facts, to the subjective rights of two individuals, but it takes into account only the validity of the statute as such, that is considered in itself, and it is only about a kind of antinomy between two norms, the Constitution on the one hand, the statute on the other. Third criterion, the American constitutional review is incidental, which means that once again, it starts with a concrete litigation between two persons, and during the debates in front of the judge, a question of constitutionality appears. Whereas in the European model, the control is said to be principal, which means that there is no pre-existing litigation, but that the only litigation that exists is the constitutional litigation. There is no litigation between Smith and Jones, but only, let's say, for example, a president of the Republic that refers a bill to the Constitutional Court. Finally, as to the effect of the judicial ruling, in the American model, the effect is said to be an inter partes effect. That means that the law will be struck down only for the case Jones versus Smith, whereas in the European model, the effect of the ruling of the Constitutional Court, the Constitutional Tribunal, or the Constitutional Council is said to be erga omnes. That means that the statute is totally excluded from the legal system, and this benefits everyone, not only the litigant that triggered the activity and the control of the Constitutional Court. So that's the traditional tool, and my feeling after having studied it for a few years is that this is not a good tool for comparative scholars. This is not an appropriate tool to account for the variety of systems of judicial review we can find in ordinary practice. And I will take just one or two examples to show that each of the criteria is not satisfactory at all. For example, let's take the centralization of the control. Of course, we can say that in the United States, the control is decentralized because every judge is empowered to review the validity of statute. But what can we do of other forms of constitutional adjudication, like the one that exists in Costa Rica, the one that exists in Estonia, the one that existed in several countries in Africa in the 1960s, 1970s? This system is a system where not the Supreme Court is in charge of constitutional adjudication, but there is no constitutional court, tribunal, or council either, which means that in those systems, constitutional review belongs to a chamber of the Supreme Court. So depending on the way we look at those cases, which are by no means exceptional, we can think that they are American, because there is no ad hoc constitutional court, but at the same time, they are close to a European model because not all the judges are indifferently empowered to review the validity of statutes, but only a specific constitutional chamber within the Supreme Court. So in this case, it is difficult to establish the distinction between a European way and an American way. Second difficulty, in other countries like Peru or Colombia, ordinary judges, as well as specific ad hoc constitutional judges, are empowered to review the validity of statutes, to exercise constitutional adjudication. These are called parallel systems or integral systems. Where do they fit into the mess of the two models? We don't know. We cannot say. Another strange case is the case of Uruguay. The control is totally centralized because only one court is empowered to review the validity of statute. But it's totally centralized, not in the hands of a constitutional court, constitutional tribunal, constitutional council, but in the hands of the Supreme Court. So who can say whether it is an American model of judicial review because there is no ad hoc constitutional court, or on the contrary, a European model of constitutional review because there is a high centralization of constitutional adjudication? What happens in countries that are typical of the European model? Well, let's just have a look at Germany. In Germany, there is one constitutional court, but this constitutional court is divided into two chambers, the Senate. Those two chambers are totally independent from one another, to the point that sometimes they are called the twin courts. So it seems that one of the best examples of the centralized European model is in fact not so centralized. Let's take another criteria frequently used by classical legal doctrine, the criterion of the concreteness or abstractness of constitutional adjudication. First, if you ask judges what they do in a European system or in an American system, it appears that their intellectual, practical activities are very close to each other. In the American system, of course, the judge will say, well, I start with the concrete litigation between Mrs. Jones and Mr. Smith. But because the American judge knows the fact that his decision might be a precedent for other courts, or other judges, or for himself or herself, he doesn't think of the case only as something that opposes this man and this woman. He thinks of the situation of those two persons as representative of a more abstract type of constitutional adjudication, of which it is only a token. So progressively, the concrete review grows abstract. And if you ask a European judge who has to decide, for example, about the constitutionality of a statute and has to compare the statute immediately after it has been passed and with the Constitution, which is called ex ante review, then in this case, it is perfectly understandable that this judge will not be only comparing the two texts. He will try to figure out the kinds of concrete cases to which this statute will be applied. So progressively, the abstract control grows concrete, so that there is no clear-cut distinction between the two. Another difficult case is the case of preliminary rulings on which are based on a very specific cooperation between ordinary judges and constitutional specialized judges. In this case, basically, we have a litigation starting between Mrs. B and Mr. A. This litigation starts in front of an ordinary judge. During the discussion, during the litigation, the debates, a question of unconstitutionality appears. In the European state, or in the vast majority of European states, but not all of them, in this case, the ordinary judge is not allowed to decide for himself or for herself the question of the validity of the statute. Once he's convinced that there is a problem about the validity of the statutes, once he is convinced that there are doubts about the validity of the statute, this ordinary judge has to refer the case to the ad hoc constitutional court, constitutional tribunal, or constitutional council. So where do we stand? with this kind of litigation, which is pretty common in Europe, in Africa, in Latin America, in Asia? Is it American because it starts with a concrete litigation? Or is it European because the question is referred to an ad hoc constitutional court who insists generally that it is making its decision only about the antinomy between the Constitution and the statute, and does not say anything about the concrete solution that has to be applied to the two litigants. So is it abstract? Is it concrete? Is it decentralized because we start with ordinary judges? Or is it centralized because we end up with a decision of the Constitutional Court? What happens if the ordinary judge in this kind of procedural situation considers that there is no problem, no doubt about the constitutionality of the statute, and that the statute is perfectly constitutional, and that the litigants are just trying to lose time when they invoke the Constitution? In this case, the ordinary judge is perfectly authorized to say, I do not refer the case to the constitutional judge. But in this case, isn't constitutional review totally decentralized because the ordinary judge makes the decision? So shouldn't we distinguish decisions of rejection, by which constitutional review in those European models is decentralized, and the cases where there are doubts, so that the ordinary judge has to refer the case to the Constitutional Court, and in this case, it will be centralized. But once again, what is apparent is that if we empirically pay a close look at the texts, at the practices, well, all the criteria that generally are used to distinguish those two models of constitutional adjudication do not work at all. My conclusion is that empirically, this theory, this widely used tool, the opposition between two models of constitutional adjudication, is flawed. The consequence is that we need new tools. So my second and final claim, not only do we need more empiricism in the study of constitutional practices, but we also need more theory, more methodology. Thank you very much.
Thank you, Professor Tissot. That was indeed an in-depth comparative analysis of the two scholarship or the two models, the American and the European, and you gave us, you enlightened the audience with going into that finer details with a lot of the cases and the examples that you have given. I'm sure the students and the academicians have greatly benefited from it. Thank you for that. I would now like to welcome Professor Dr. Yogesh Pratap Singh. He's the Vice Chancellor of National Law University, Tripura. So,
yeah, thank you very much, Professor Tagi. All the distinguished professors, colleagues, and participants. It is a great honor and privilege for me to be invited by MIT University to speak on a very important and relevant topic, comparative law and comparative legal studies. This field of study with its roots in understanding legal system across different jurisdictions holds the key to the various intricacies of law in a globalized world. Comparative law had traditionally been seen as a method without substantive import. However, comparative law is now recognized as having a contribution to make to both international law and order and the study of legal history, anthropology, and philosophy. The focus in comparative law has also changed from a narrow technical emphasis with general classification of families or styles of law. We classify legal systems as common law, civil law, religious law legal system, socialist law legal system, or the most common, the hybrid law legal system, and now into a more unified historical, cultural, and practical perspective. A study of comparative law has also evolved into a study of legal systems. Therefore, some people prefer the phrase comparative legal system rather than calling comparative law. As a matter of fact, we teach in our postgraduate courses a compulsory paper on it is prescribed by the UGC as a compulsory paper for our PG students in law, comparative legal system. We briefly discuss in UG courses also when we introduce the students of law to the law. We teach a paper called legal methods, and in legal methods we briefly introduce the students about various legal systems, common law, civil law. The significance of this evolution not only has consequences for legal theory, but involves legal theory. And the change in the focus of comparative law is part of a reorientation of legal theory from the study of rules and concepts of law to the study of experiences of legal system as social orders. History, anthropology, philosophy contribute to this reorientation. And hence, the goal of comparative law as a universal system of law and order has been, and hopefully always will be, a source of inspiration for all who are concerned with the legal system and the law. From rather humble beginning, comparing legislations and confined to private law areas, comparative law has come a long way within just over a century. The history of comparative law runs parallel to the history of ideas, probably. It is as old as science of law. The earliest comparative law work we found in Greece. We get this information that Aristotle, while considering what form of political community would be best, studied 153 constitutions of Greek and other cities in his treatise Politics. We also have information that at the time of drafting the Athenian laws, drafters carried out comparative law inquiries in the Greek cities and finally gave the famous Roman 12 table. In the Middle Ages, we also have information that canon law and Roman law were compared, and people debated and discussed the merits and demerits of canon law and the Roman law. But we say that formally, the discipline started in the year 1900 with the World Congress in Paris. But the areas which are covered and the methods which are used, the projects involving the comparative approach in many of its forms, the increasing numbers of comparative law journals, comparative law associations were formed. All these flourished in 20th century. And the uses of comparative law and comparative legal studies still continues to excite and involve us in the 21st century. Since the beginning of 19th century, when the private law in Europe, continental Europe, was nationalized by way of codification, the modern European comparative law started developing. Comparative law journals were established. Comparative law societies were formed, because the main purpose of the comparative law was for a long time to provide inspiration for the state legislation. At the same time, comparative law experienced some limitations also. For instance, it was generally concentrated in Europe, the law in former colonies, with the exception to United States, was not seen as sufficiently independent and was largely ignored. Non-European legal system that had not been supplanted by the European law, especially in Asia, Africa, and in the Pacific, were also excluded from comparative law and were relegated to a newly developed field of legal ethnology. Another limitation which was seen was comparative law largely concentrated initially on private law, which was viewed as apolitical. And therefore, it appeared to be the only area of law which was fit for a strict scientific legal comparison. Comparative law was long focused on comparison of legislative texts, especially between the continental European legal system, which were divided into different legal families. I already mentioned civil law based on their origins, whether it is French origin or German origin, or it is English origin common law. But the jurisprudence of comparative legal system implies how the subject matter of the law has taken shape when it is viewed from a comparative perspective. The perspective and the subject matter obviously are interrelated, so that as one changes, it affects the other. And therein lies the key to the development of comparative law in the narrow sense of jurisprudence and in the wider sense of legal theory. However, it is more complex than the contrast between theory and practice. For example, it is said that the debate began with the study of primitive law. For instance, Pollack, he believed that it made no difference whether one talks of comparative or historical jurisprudence, since the expectation was to discover the universal principles in the development of law. And such principles include Henry Main's famous dictum that movement of the progressive societies has been a movement from the status to contract. Yet, in Pollack's, in his own word, he writes that comparative jurisprudence was as significant as a handmaid to the theory of legislation. In 1900, during Congress of Comparative Law in Paris, two alternative views were also emerged, one from Selle and the other was from Lambert. The Selle perspective was practical, while Lambert's was intellectual. To Selle, the potential of comparative law lay in a legislative common law. And for Lambert, comparative law was useful to discover the natural laws of legal development. This dynamic confrontation between comparative law for the narrow purpose of developing an international, transnational, or common law in a scientific or
So you're on mute. Professor Singh, you're on mute. Professor Singh? You're on, Dr. Jain, can you unmute?
Is there?
मैम वो है बट वो अनम्यूट करना पड़ेगा आपको मैम
Mute कैसे करेंगे?
relationship between families of legal system proves that comparative law is not merely a method, but rather it unites all the selective disciplines of legal theory. Such disciplines include legal anthropology, legal history, sociology of law, political science, together with all the creative disciplines of international law, in a study of the very relationship between rules of law and the conceptions of law. Its utility is great in legal domain. It is useful to the legislators and the law reformers alike. As a matter of fact, when a law reform committee is constituted in any country, Government of India, Government of States also keep on constituting various committees. They also study various both macro and micro perspective of various other foreign jurisdiction. For instance, in the justice delivery system, especially the criminal justice delivery system, which is struggling with various kinds of issues like areas, delay, several committees have been constituted. Law commissions have been given reports on these committees. And while doing this study, they have studied and they have suggested, they have examined the legal system of various other countries, various other legal systems, and they have suggested that why we should not incorporate and borrow the features of some other legal system. Like, for instance, Malimat committee recommended a long back that we should incorporate some of the features of inquisitorial justice delivery system, which is prevalent in continental Europe. It has great value in international relationship. Its utility is great to the community at large, both in national and international spheres. It provides framework to the legal practitioners for handling legal problems involving foreign laws. Professor was referring Indian Supreme Court judges. When we read Supreme Court judgment, we find our judges are very fond of referring foreign precedents. So you take any judgment, any leading judgment of the Supreme Court, Indian Supreme Court, you will find a number of, whether it is from United States, it is from Europe, it is from Australia or Canada. As a teacher of constitutional law, I also used to discuss cases from US Supreme Court, cases from Australian court, for cases from Canadian court. In fact, we had the opportunity to attend a course in France, International Institute of Human Rights, where we were exposed to the decision-making process and the landmark judgments of the European Court of Human Rights. And I find some of these cases are so useful when we teach freedom of speech and expression, when we teach various other fundamental rights under Indian Constitution. We find that referring these landmark cases from European Court of Human Rights makes more useful contribution. So comparative process is useful in comparative jurisprudence, comparative legal history, constitutional and administrative law, criminal law, labor law, commercial law, rules of processes and procedures, legislations and law reforms, and what else? International law and international relations. So while comparative law and comparative legal studies offer so much of insights, they are not without challenges. There are limitations, differing legal traditions, linguistic barriers, and varying research methodologies. They pose various kinds of hurdles. However, these challenges gives us opportunity for collaboration, innovation, and the development of what I call inclusive approaches to legal scholarship. So I would stop here. Thank you very much for giving me this opportunity.
Thank you, Professor Singh, for highlighting the fact that we have included the comparative legal theory aspects into a curriculum that we are offering the students, giving them ample knowledge about it. However, the need for enlargement of the jurisprudence, which does exist even now, but a lot more work to be done on that front with the challenges to face. And I think the academia can come together for resolving or having more interactions to bring up a solution or enlarging our knowledge base in this. Thank you, sir, for that. I would.
Sagi, I believe we'll wait for 2 minutes and then we'll continue. We are just waiting for Bajpai sir to join. Okay. Okay.
Can the participants probably ask a question or two to the existing panel if they would like? Is that possible?
Yeah, that can be done.
Yeah, because including me, I'm curious about many things. So if any of the student can or any of the professors here would like to address, we have the experts here with us, so it will be good. You can post it in the chat or maybe raise your hand. We have a couple of minutes for it. There's a good opportunity for the participants. If you have any doubts regarding the what the expert have spoken about the comparative law aspects, anything that you had, probably it could be even a basic doubts, please raise it now. It's a good platform for you.
We need to develop this culture of asking questions.
Yes. Yeah. I would expect that from, I would have expected many questions right now. That's the nature of, in the academia, we have a lot of students asking questions. I probably a little reluctant when they didn't expect this. Yes, there is something. To Professor Singh, sir. It says, what is the difference between comparative law and transnational law, and what are the parameters for distinction? It is addressed to Professor Singh. So, can you hear me? You're on mute. So not audible. On mute. Dr. Jain, is it possible to unmute Professor Singh? So we cannot hear you actually. If any of the admin can unmute, sir, I'm. So can you unmute yourself? Okay, I really don't know what happened. Probably some issue with the laptop computer. I think Professor Singh has joined us again.
Yeah, I believe there was a technical glitch, I believe so. Professor Yogesh, yeah, can you unmute?
Can you hear me now?
Yes, we can hear you.
Perfect. Perfect.
Okay.
Sir, there is a question addressed to you from Dr. Abhishek. He's asking what is the difference between comparative law and transnational law, and what are the parameters for distinction?
A distinction between comparative law and transnational law. Comparative law, as I think, involves a systematic study and analysis of legal system across different jurisdiction, where we identify similarities, differences, underlying principles, methodologies that govern diverse legal traditions. The comparative approach provides valuable insights into the evolution of legal system, how common law, how civil law legal system has evolved. It offers a broader perspective that transcends national boundaries. But when we talk transnational law, it extends beyond the confines of traditional legal framework. It addresses legal issues that arise across borders, involves interactions of individuals, interactions of various institutions, corporations. Transnational law also recognizes the interconnectedness of the legal system, and the focus of transnational study is on the legal phenomenon that traverse national boundaries, such as international trade, human rights, environmental regulations, etc. So we have cross-border legal harmonization, we have cultural sensitivity and legal pluralism, we have global legal education, we have adaptation to legal technological advancements. So the interplay between comparative law and transnational law is, in my opinion, instrumental in shaping the modern legal landscape. As we start from the complexities of a globalized world, the collaboration between these fields become very, very important.
Thank you, sir. I hope it answered the query. It was well explained by sir. Dr. Jain is Professor Bajpai joining us, or because I'm having
You can take the, there are two
Yeah.
more questions. After that, we can go for. Okay.
If any of the other
There are
professors.
two questions in the chat box. So
Yes.
if you can read it.
Yes, yes. So one of the question is there any established methodology of comparative analysis? Like say, if you want to compare artificial intelligence regulations, laws of jurisdiction, what are the basics and where should I begin with? And it's open to any of the experts, the panelists. If they can guide the student. This is Shikhar Gupta asking if there is any established methodology of comparative analysis.
There is, in my opinion, there is no established methodology in comparative analysis. There is no established methodology in law, in the field of law. We borrow methodologies from various other disciplines, whether it is sociology, whether it is anthropology, whether it is economics, whether it is history. So we don't have our own methodology.
Yes, sir, thank you. And one more thing, one question from Shantanu. Can the Indian Constitution be considered a work on comparative law? That's
Yes, up to certain extent, because I referred when I started that Aristotle, I studied around 150 constitutions when he wrote his book Politics. So when our constitution was drafted, it was also the drafting committee referred the various other constitutions of the world, and they found so it is contribution and it is the outcome of a comparative work. There is no doubt on that. So we studied various other constitutions of the world and we borrowed some good things from various jurisdictions and we incorporated.
Thank you, sir. We have no more. Yeah, those were the three questions that were asked by the. So just because we're waiting, one of the thing that issues we have had here in the Dubai jurisdiction, here is the language where you talked about the difficulties, challenges, and interpreting something from another language has been a very big challenge that we have been facing in here in Dubai or in UAE, or I'm sure in Middle East, other countries also, because when I was doing practice, there was a matter from Italy, and the documents were in Italian. It was translated to English and then to Arabic, and then it got retranslated to English. So it's like lost in translation across. By the time it got to the final translation, God knows what kind of interpretation that the courts can make out of it. So it's a big challenge, which or one of the big challenges that we face here in terms of applying a foreign law here or interpreting that particular law.
Yes, true. Our Supreme Court is also trying this kind of exercise. So judgments are written in English. Now it is being translated into Hindi so that common man can understand the decisions of the Supreme Court. But I don't know how far it will be successful. But there are challenges. There is no doubt on that.
Yes, sir. Absolutely. For those students who are here, this is the best opportunity. Sir is here with us. The experts are here with us. You are free to ask question. I mean, you have this extra bonus time where you could ask questions to sir, the panelists. Please use the maximum as much as possible. Dr. Jain? Dr. Jain, are we waiting for Professor?
Yeah, sorry for the delay. There was a technical issue. Professor Bajpai is joining within a minute or two.
Okay.
Okay.
Our students are not keen to ask questions that I understand. Is that so?
Mobin, एक बार check करना Bajpai sir has joined.
लॉबी में तो नहीं है
Whether he's in lobby. Mobin.
No, ma'am, not yet. I already sent the link to Bajpai sir, ma'am. Ma'am, I'm sending Bajpai sir link to you on your WhatsApp.
Okay, okay, sir. नहीं थी देख रहा था कल रास्ते पर देख रहा था जब आप Dr. Sagi. Yeah, there was a technical issue, so Bajpai sir is not able to join. So,
Okay.
and also Shantakumar sir is also not able to join.
All right. Okay. I think then we can.
He is traveling.
Okay. Okay. Fine.
So citation है next after. Yeah, we'll just citation. Yeah, we'll just read the citation now.
Okay.
Yeah.
एक स्लाइड बनवा दो एक स्लाइड
Share. Okay. Third one. Share. As a token of our appreciation to our panelists, those who have joined today and shared their valuable inputs, we'd like to present our token of appreciation and gratitude for being a part of the International Conference on Comparative Law 2024. We'll just share the citation. Okay. This citation is presented to Professor Dr. Yogesh Pratap Singh in the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Professor Singh is a renowned personality in the area of constitutional law and human rights. His exceptional knowledge on law is phenomenal, and his writings are awe-inspiring and thought-provoking. We are thankful to Professor Singh for investing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Professor Singh and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Next, we have the citation for Professor Antony. This citation is present Ninette. I believe I've pronounced the name properly. In the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Professor Antony is a keen learner and researcher for updating the comparative constitutional law. A dynamic personality with abundant expertise and enthusiasm, Professor Antony is an epitome to reckon in the field. We extend our sincere thanks to Professor Antony for sparing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Professor Antony and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Second. Next. William. Sargi, am I audible?
Yes.
Okay. The citation is presented to Professor William Tussaud in the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Professor Tussaud is a zealous scholar of international law and constitutional litigation. An ardent crusader in the area of comparative public law, Professor Tussaud has proven his niche in academics through the years. We are grateful to Professor Tussaud for investing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Professor Tussaud and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you to all the panelists for sparing their time and gracing this occasion. Over to you, Dr. Sagi.
Thank you, Dr. Jain. So as we come to the end of this session, I would just like to leave with the note that comparative, this conference is very, very relevant because comparative law is becoming more and relevant these days with a lot more of transnational cases coming up, and in various courts we see here the cases from different jurisdiction being applicable in the various courts of different countries. So comparative law becomes very, very relevant, and there is a need for more the students and academicians to dwell deeper into this area, and hopefully we'll have a advanced set of knowledge that can permeate across the entire comparative analysis area or comparative law area, I would say that. With that, I thank the organizers for inviting for this, for all the panelists who have spoken today, Professor Anthony, Professor Tusso, Professor Singh, for enlightening the audience, the students, and all the other academicians with your immense knowledge. Thank you all, and have a good afternoon.
Yeah. Thank you so much, Dr. Sagi.
I can leave.
Yeah, you can leave. We'll have a short break of half an hour. We will be resuming at sharp by 20 minutes from now. We'll be resuming, and the session will start exactly at 2:30 Indian time. हाँ हाँ मोबिन ऐसे ही रखना, लीव मत करना, एंड मत करना.
Okay, ma'am.
Sir. Yeah. Sir, we can start. We can start the session, sir.
Yeah. So a very good afternoon to one and all present here. So today we are, as a part of an extension of the of this conference on international conference on comparative law. We have an esteemed group of members who would be deliberating in this session, in this keynote session. We have with us Professor Dr. Martina Caroni, but I believe she has not been able to join because of some instrumental reasons. We have Professor Mauro Busani, professor from the University of Trieste, Italy. We have Professor Renata Deskoska from Macedonia. We have Mr. Hemang Shah, the Director of Engineering, Kuala India Private Limited, Bengaluru. We have Dr. Ivan Swatrivan. However, because of some reasons, we would only be able to hear her voice. And then followed by that, we have Professor Dr. Shailesh Hadley, the Registrar, Dharmashastra National Law University, Jabalpur. And we also have with us Professor Catherine Velke, Professor, University of Toronto, Canada. I believe she would be joining us very shortly. And Professor Ulla Lukanen, Professor, Faculty of Law, University of Helsinki, Finland. So we will go by this order, and we hope that in the second session on this naive subject that we are trying to discuss, we will have thoughtful insights and discussions. So without much ado, I would request Professor Mauro Busani to start with his deliberation. But before I ask him to do that, may I please be allowed to introduce Professor Busani. Now, Professor Busani is from the University of Freiburg, Switzerland. He is a professor of comparative law at the University of Trieste, and an adjunct professor at the University of Macau, SAR of the People's Republic of China. He is a titular member of the International Academy of Comparative Law, and he sits in a number of councils, including the famous Swiss Institute of Comparative Law. Apart from that, he is also instrumental in serving many other bodies and associations, including the Interdisciplinary Association of Comparative and Private International Law, which is based out in Austria. Apart from that, Professor Busani is a member of the editorial board of many of the very revered law journals, including the American Journal of Comparative Law, the Tulane Law Review, the Journal of European Tort Law, the Journal of Comparative Law in Africa, and many other law review journals circumscribing law, especially focusing on comparative law. And he has about more than 30 books to his credit, and about and quite a few articles, including essays that have been published not only in English but in Italian and in French. And so it's many, you know, we are honored to have him in this board and to have him start the discussion on international comparative law. Then without further ado, may I ask Professor Mauro Busani to take the stage, please.
Good afternoon. Thank you very much for this kind presentation, and thank you very much to the organizer of this wonderful conference for inviting me to speak in it. Now, as is well known, the study and practice of comparative law can be conceived in many ways. One of these ways may lead one to focus on the relationships between law and society, and to study how official rules coexist with other unofficial sources of law. This avenue is the one I will pursue in this presentation. Indeed, as is well known, political and legal theories have long been taken for granted. The idea that law is the province of government and government-recognized authorities, be they national, subnational, or supranational. What matters as law from this perspective is the set of processes, principles, rules by which the form and substance of state law are determined, implemented, and enforced. This law is what I call official law, or state. By contrast, many non-official sites of legal production have always existed and still exist inside, outside the West. These sites produce rules that might flourish indifferent or in opposition to official law, and take the settlement of disputes arising out of the application of those rules outside the ordinary circuit of adjudication. Even though the discussions about the relationship between the unofficial and official rules of law is one of the most ancient legal debates, stretching back centuries. In the last 200 years, the Western positivistic attitude has been able to obscure the multifaceted dimensions of legal experience, and it has been able to fence them off from the spotlight of critical investigation. Yet, in the last decades, the unofficial dimension of the law has gained new scholarly traction. Also from the domestic perspective. Anyway, law and society scholars inquire into the social structures that induce compliance. Law and economic scholars examine non-state law rules and institutions that allow or should allow, in their view, for efficient and desirable social results. Law and psychology scholars scrutinize the motivations that ground loyalty to non-state and or to state law. And all these scholars profit or should profit from the long-trodden path of legal anthropologists and from their findings on the cross-cultural features of social ordering, as well as from legal historians' studies on how private and commercial law has been thriving for ages in the absence of constitutions, almighty legislatures, and state courts ordering. The way I read this, the existing literature and field studies from a comparative law perspective, is meant to show how state law tends to control the relationships and disputes between people who are strangers to each other. Because whenever there is a bond tying together a group of people, such a group tends to have their relationships and disputes controlled by the different set of rules. This different set of rules may have diverse origins, customary, religious, professional, but they are daily relied on by hundreds of millions of people. And by the way, they control markets worth hundreds of billions of US dollars or euros or whatever. Some caveats are in order, though. And conventional and all Western dividing line between norms and the law sees law as the subset of norms that are created and enforced by government. Instead, relying on the reservoir of comparative law knowledge and findings, one can take law in its broadest meaning as the set of rules that any group, any community, any society recognizes as binding and enforceable through positive or negative sanctions. That's to say, through a reaction or the threat or a promise of a reaction by the members of the group showing approval or disapproval of a conduct. Indeed, as Michael Reisman, Lawrence Friedman, and many other comparativists remind us, the term law can be applied to processes of many kinds, even those that are or seem to be very far from the features of the official legal system. Any group of any nature and size has rules and tries to enforce them. What makes them like official law is that they are recognized as binding and enforceable through positive or negative sanctions by the concerned group. What makes them, in the eyes of the mainstream debate, unfit to be labeled as law is an all-Western intellectual posture grounded in history and self-interested path dependency. Self-interested path dependency. To make this, the latter point clear, let me start with underlining that what is common across disciplinary fields is the use of the label informal as the controlling adjective to describe any sort of legal arrangement or enforcement that does not stem from state law. This is inaccurate, and to a certain extent, even an unfortunate choice. As always, language is telling, though. Language is telling. In fact, the inaccuracy in the use of the term informal as a cultural pedigree, which is worth disclosing. First, as I said, most of the participants in the legal debate identify the word law exclusively with explicit product of the state. This compels dissidents to underline the adjective non-state, informal, soft, customary, or as in this presentation, unofficial when discussing any other type of law. Excuse me, moderator, I keep listening to rings, bell rings. Is it normal? Is it?
I believe, Professor, I believe there are some entries which are happening. I'm very sorry. If I may check.
Okay, no, don't worry. Thank you very much. So there always is the need of underlining a different adjective when one dissent from the official mainstream posture. But when the mainstream debate has to face the potential deficiencies of this posture, a series of intellectual strategies are deployed. Two of these strategies are common: denial and accommodation. One that can describe these strategies as follows, on the shoulder of a great scholar, as it has been, the late Roderick MacDonald. Denial. Denial is a simple strategy. It relies on the assumption that any data challenging the mainstream approach is either unreliable, misconstrued, irrelevant, or said to evidence no more than a failure of analysis. Denial simply requires the repeated assertion that all law comes from the state and that accepting any other definition would blur the borders of the law, undermining its role in society and opening the floodgates of the legal system to chaos. Accommodation is different, partially different. Accommodation rests on the idea that if sometimes law may appear irrelevant or unfit to rule the social or economic phenomena, this simply is a descriptive deficit or the result of society's overinflated and unrealistic expectations of law. Should one scale down the expectations of law's reach, any failure would appear either as a failure of understanding reality or as a failure of adapting the law to it, and but maybe easily fits through more appropriate doctrines or through an intervention of the state law itself. Needless to say, these strategies are each designed also to preserve an intellectual and professional status quo. To all the limited definition of law allows official legal debate and actors to keep on theorizing that law's universe is dynamic, but within strictly defined borders. Beyond the latter borders, by the way, it becomes hard to imagine law schools, textbooks, lawyers, judges, and technocratic and bureaucratic apparatuses as we know them. And this is enough, in their view, to falsify or discredit any different theory claiming the existence of law outside those frontiers. This mainstream attitude needs, however, to come to terms with a widespread phenomenon crisscrossing all societies, Western or otherwise. In fact, as I said, there are many examples coming from field studies conducted in many sectors of social life and business activities, showing how in those sectors, unofficial law reveals itself as the controlling factor of public and private behavior. The reference goes to families, religious groups, and some of the related food industry, to social, professional, business, financial communities and networks, to online communities, to ethnic communities, to communities of neighbors, and to most of the employment and workplace relationships, and to an array of other locations of human interactions that may be seen and do function as sites of legal regulation. All these field studies bear out that unofficial law finds its way through social and economic groups and represents the controlling factor of their activities and of their disputes. In all these groups, people recognize their own rules as binding, and the latter applies also to the disputes arising within the scope of group self-determined laws, without having recourse to the official circuit of adjudication. Sometimes the recourse to the official circuit of adjudication is even prohibited. Well, bearing in mind all this, it becomes possible, I think, to shorten the distance that may keep us from understanding the legal dimensions our societies live by, and to clear the dust of rhetoric about the legal monotheism wherefrom we usually observe the legal world. Indeed, official law and its adjudication circuits appear to be, as I said, appear to be law and circuits designed to control essentially relationships and disputes between strangers. That's to say, people who may know or not know each other, but do not share the same group identity, do not pursue the same interests, don't necessarily trust each other, or not enough to be certain that one's own values, beliefs, and priorities might be plainly understood and shared by the others. In principle, between strangers, there's no steady certainty, common meaning to be given to things, qualities, behaviors, expectations. And this is precisely why any society which comprises different communities carrying on diverging values, interests, and objectives needs official law, needs third-party impartial enforcement regime. We need official law precisely because several independent systems of laws do exist and involve perforce ambiguity about the boundaries between them. We need official law to dismantle unjustified privileges that may be granted by unofficial laws and to counter possible forms of discrimination, including those that may take shape when a member of a group ruled by unofficial law wants to or is forced to exit from that group. We need official law because we live in societies where a good number of interactions and conflicts simply occurs between people who are strangers to each other. All these does not mean, however, that there is less scope for us to practice our strangers-free ways of life. Despite our dependence on strangers, we all have families, we have friends, and we have strong personal and professional ties to individuals and groups. All of us spend much of our lives in tiny groups, in our personal sphere, and inside our groups, inside our personal sphere, unofficial rules control. Unofficial rules control. In fact, given that we live in societies made up of large or small minorities, where common moral bonds across ethnic, religious, and social groups are bound to be looser and looser, or as shown to be looser and looser, the recourse to group or communitarian dimensions is increasing. So too is the role played in the overall legal scenario by unofficial laws grounded on group, community values and interests, and on our appraisal of what we are and of what we are doing. Now, to approaching the concluding remarks, from what I said so far, the most important lesson one can draw, and I'd like to submit to your attention, is that overlooking the sets, let's put it this way, if we overlook the sets of unofficial laws, the different sets of unofficial laws, we leave behind us a piece of the real legal world that survived to our ignorance in the past and will outlive our kind in this regard. What is enmeshed in unofficial laws are the multifaceted fabrics of our societies. And if we keep looking down on the legal offering of all this, or we miss a cognitive dimension of the law, whose laws, among other things, should urge one to define herself not as a lawyer, judge, or legal scholar, but as state law lawyer, state law judge, state law scholar, and nothing more. This is one of the fallouts, the battle of definitions about what is law should carry with itself. To be sure, setting borders functional to institutional arrangements that need to keep clearly separated state law from the rest of the legal dimensions has proved successful in the last 2-3 centuries and represents a culturally legitimate attitude. It is a culturally legitimate attitude, but it is grounded on a series of neither transcendental nor immutable, but historically construed notions. And the refusal to acknowledge it, acting as a sort of ministers of a legal monotheism, reveals nothing but a path-dependent, all Western-centric way of looking at the law. A profitable way, too, as I said, in view of preserving an intellectual and professional status quo. Taking stock of the foregoing may also explain, I think, why a comparative law perspective is much needed in order to seize the ways the laws both reflect and structure human relations. Such a perspective would call into question common views of official and unofficial law, would connect mainstream visions about law within the broader social context where law and justice live, in the different jurisdictions, in the different societies, to delve beyond conventional wisdom and to better understand through comparative law lenses the different legal dimensions across the cultural, social, and professional frameworks in which the laws operate and are embedded, would be both the promise and the challenge of comparative law. Indeed, it may surprise some outside of the audience of this conference, needless to say. It may surprise some and even displease others, but comparative law does matter. It matters also because it takes the modalities of thinking about law away from its bureaucratic visions, away from the aridity of its metaphysical visions, which, let me say, like the metaphysical visions, which like those of the ancient soothsayers, are often believed to be close to the truth only because they diverge from reality. But comparative law matters also, and this is my concluding remark, because once we place it before the mirror of the variegated conglomeration of phenomena and of legal phenomena that affect us, comparative law makes it possible before that mirror that, as happened to Alice, in the transition from one side of the mirror to the other, our way of looking at the world be no longer the same. Thank you very much for your attention.
Thank you, Professor Busani, for your insightful observations on informal laws. Actually, we must reminisce, actually going by your insightful observations, that we will miss the cognitive dimension if we do not recognize unofficial laws. And in order to make comparisons more easier, we must not lead to legal monotheism by believing in positive laws or stated laws, and we must look beyond the stated laws. And the wonderful observations, Professor Busani. Next, we will have a deliberative session, maybe post the keynote session is over, and may we invite as a second in this panel. Professor Renata Deskowska, Professor Istinius, Primus Macedonia. And before I would like to introduce Professor Deskowska. Professor Deskowska, Professor Dr. Deskowska, she obtained a PhD in the Faculty of Law in Ljubljana in 2002 on the topic of constitutionalism, constitutions, and human rights. She was also an elected member of the Office for Democratic Institutions and Human Rights, the institution which is based out in Warsaw, Poland, and in the advisory panel of experts on freedom of religion or belief in 2012. And she has also been she has also worked as a domestic expert on the legal and institutional framework for inter-ethnic dialogue, and as a member of the working group, worked as a member of the working group for the preparation of the national strategy for the integration of the Republic of Macedonia in the European Union, and in 2003, and as an advisor on constitutional and legal affairs in the cabinet of the President of the Republic of Macedonia between 2004 and 2009, and an ad hoc as a member of the ad hoc commission for investigation of the events of December 2024, December 24, 2012. Apart from that, she has participated in numerous conferences and in roundtables, and has published more than 38 papers in English and about 14 papers in Macedonian language. She has also held the post of the Minister of Education for the Republic of North Macedonia between the years 2017 and 18, and the Minister of Justice of the Republic of North Macedonia between the years 2018 and 2020. Presently, she's presently working as a professor of constitutional law and political system at the Faculty of Law Scope, University of Krill and Methodius. So over to you, Professor Deskowska.
Thank you very much. Dear colleagues, ladies and gentlemen, it's my pleasure being today with you on this conference. Upon receiving the invitation to be a keynote speaker on this conference, my mind immediately wandered to my memorable visit in India in 2019. And I recall the warm hospitality of the people and invaluable experience that I gained from New Delhi and Lucknow. My time in India significantly influenced my perspective on comparative law and reinforced my belief of the importance of cultural relativity in understanding universality of human rights, as well as the need of comprehending law within the local and national context. And my travel there reminded me to the words of Professor Gunther Frankenberg, who almost 40 years ago wrote that the comparative law is like traveling. The traveler and the comparativist are invited to break away from daily routines, to meet unexpected and perhaps to get to know the unknown. Traveling promises opportunities for learning, both about one's own country and the culture about other countries and cultures. But going to new places and to the strange world do not, however, automatically open new horizons if you see only landmarks. You have to see also the details, you have to see the background, which means that it's not only enough to see fascinating Taj Mahal, but also real life in the streets, markets, in order to better understand India. When I was in India at that time, your Supreme Court issued a landmark decision in the Aidoha case, which holds significant relevance for the comparative constitutional law, particularly in the discussion surrounding religion and religious rights. In today's globalized world, the constitutional law cannot be understood anymore if it is learned only from national perspective. In the time of global communication, the national constitutional systems are not immune to the influences from other systems. Constitutional lawyers are inherently comparativist, compelled not merely by their curiosity, but by the imperative to comprehend their subject of interest thoroughly. But to learn comparative constitutional law means to confront also with the philosophy of other legal systems, with the meaning of constitutional concepts. For instance, one cannot discuss about UK constitutional law without grasping the essence of the term rule of law, nor can the meaning of the term Rechtsstaat or legal state be disregarded when studying German constitutional law. So to learn comparative constitutional law means to attempt to understand what is behind the constitutional norm, what is meaning of the words used in the constitution and the practice behind. To do comparisons in the constitutional and other public law is more difficult than in private law because public law is more shaded by national elements than the private law. History, political culture, social economic circumstances have more influence on public law than in private law. That poses difficulties because the modern comparative constitutional law embraces law, history, culture, and spirit of the people of the certain country. Despite the difficulties, there are important reasons for using comparisons in constitutional law. Comparative law is important because it provides assistance in the legislative process. It is instrument for promotion of legal unification. It serves as a tool for legal interpretation, and it facilitates study of constitutional law. These days, for example, all of us professors of constitutional law around the globe are following the decision of the United States of America Court about the ex-president Donald Trump's demand for immunity in 6th of January case. This ruling is not only important for US because also many other countries have the same constitutional provisions of immunity of the president, as it is, for example, in my country, Macedonia. In our constitution, we have general provision that the president has the immunity without further elaboration. This provision has never been implemented till now. If ever the constitutional provision has to be implemented, our judges will have to search for comparative practice in order to interpret it and deliver judgment. And it would be unavoidable to study the reasoning of the US Federal Appeals Court. So comparative law is an important instrument for legal interpretation. Today, I would like to speak more about comparative law as an instrument that assists legislative process, an instrument for promotion of legal unification. I would like to speak about these questions from the perspective of a member of Venice Commission. Since 2020, I have had the privilege of serving as a member of European Commission for Democracy Through Law, shortly called Venice Commission because it holds its meetings in Venice. The Venice Commission is an expert body of Council of Europe with primary task to provide states with legal advice in the form of legal opinions on draft legislation or legislation already in force, which is submitted for to it for examination. Venice Commission also produces studies and reports on topical issues. The web page of Venice Commission is a valuable source of comparative studies and examples in the field of constitutional law, and I strongly recommend it for constitutional scholars interested in European, primarily comparative constitutional law, but also there are also opinions for countries that demand from other continents, from Africa, from Asia, etc. In the recent years, the Venice Commission has undertaken various initiatives, including reports and studies on term limits of the presidents of the state, the relationship between political and criminal ministerial responsibility, the role of the opposition in the democratic parliament. There is a rule of law checklist published also on the web page. We made comparative analysis on constitutional framework on emergency situation and activities of state bodies during COVID-19. There are studies on independence of judiciary, comparative study on judicial appointments, etc. Additionally, comparative studies on amnesty laws and normative competencies of executives are currently underway. Through these reports and opinions, the Venice Commission plays an important role in the unification of the constitutional law in Europe and countries outside of Europe that demand opinion. In contemporary world, the unification in the field of human rights is done through international conventions. In Europe, we have the European Court of Human Rights as effective instrument for implementation of the European Convention of Human Rights. But Council of Europe, through several bodies, including the Venice Commission, try to contribute to unification of the norms of the judiciary in the countries that are member of Council of Europe and those other countries that want to implement the highest standard for judicial independence. The reality is that there is a great diversity and there is no uniform model of judicial governance in Europe. But one of the key recommendations of any commission, in its opinion on the independence of the judiciary, is introduction of judicial council and as constitutionally established body. Another recommendation is that if this judicial council is included, the council that will elect judges or appoint judges, then the recommendation is that not less than half of the members of the judicial councils should be judges elected by their peers. In order to prevent politicization, however, the proportion of judges should also depend on other features of the system. But also, the presence of the non-judicial members in the judicial councils is crucial to mitigate corporativism and to provide democratic legitimacy and accountability of this body and of the judicial system as a whole. When lay members are elected by the parliament, Venice Commission recommends that it should be done with the broadest consensus in the parliament, in principle by qualified majority vote, which involves the opposition following an open and transparent competition. Of course, effective anti-deadlock mechanisms should be provided. Because the majority of the members of the judicial councils should be judges elected by their peers, Venice Commission recommends that the president of the Judicial Council is elected from among the lay members of the Judicial Council. Venice Commission also stated that it is controversial if the proposal for appointment of the judges came from the Minister of Justice. Such system allocates undesirable power to the executive in the field of judicial appointments. It creates a risk that political considerations are taken into account when proposing candidates for judicial posts. Why I'm speaking about these provisions in the judiciary? Because I want to compare and to show the comparison between Western European countries and Eastern European countries in implementing this recommendation and the results that came out from this. So in practice, some Western European functional democracies, we can find examples in which executive power has important role in the appointment of judges. For example, in the Netherlands, the state councillors, which are judges of the highest administrative court, are appointed by the king on the nomination of the Minister of Interior in consultation with the Minister of Justice. So the procedure for appointment of the state councillors in the complete competence of the executive power, monarch and ministers. On the other side, on the basis of the data from 2023 EU Justice Scoreboard, we can read and see that the level of perceived judicial independence in Netherlands is very high. Overall, 77% of general population and 72% of companies perceive the level of independence of the courts and judges in Netherlands to be fairly or very good. And the Netherlands is completely out of line with the legal standards for organizing judiciary that are promoted by the bodies in the Council of Europe. I mean, these standards which are tackling the issue of judicial appointments and the trust in the judiciary. Nobody sees that, or there are no suspicions that actually the judicial there are no suspicion that judiciary is politicized in this country. Different from that, in my country, North Macedonia, the level of trust in judiciary is less than 2%. I was a Minister of Justice from 2018 till 2020, and in that period, we took over reforms in the field of judiciary and adopted legislation that was sent to evaluation to relevant bodies of EU and Council of Europe. Their external evaluation was that the legislation is completely in line with the highest European standards. Since Macedonia is candidate country for the membership in EU, every year we are evaluated by the European Commission. The reforms that were made in the period 2018-2020 were positively evaluated in the progress reports of the European Commission for these years. But the last 2 years, in 2022 and 2023, there were negative trends in functioning of the judiciary that led toward loss of trust of citizens in it. These two examples, Netherlands and Macedonia, show that constitutionalism and rule of law can be established even in the legal system with bad legal norms, as well as that the good legal frame is not guarantee for establishment of constitutionalism. This example also teaches us that we should be careful with transplanting comparative or even international standards. Not all grounds are good for same standards. For example, the recommendation that majority of the members of the judicial councils should be judges elected from the judges, supposed to be guarantee for independence of the judiciary. But when you face with corrupted judiciary, then the majority of the judicial council is not the guardian of the independence, but unfortunately for corruptive practices in the judiciary. In Netherlands, for example, the Minister of Justice has the right to give general and specific directions to the public prosecutors concerning the performance of the duties and exercise of the powers of the public prosecution service. The Minister of Justice can issue direction to the public prosecutor not to investigate or not to prosecute a case, or to discontinue an investigation or prosecution, but can also give instruction to investigate or prosecute a case. This right was never used by the minister in Netherlands, but despite that, there were unsuccessful legislative initiatives to delete this competence of the minister. The attitude of the government of Netherlands on this issue during the legislative debate was that the Minister of Justice is responsible for the functioning of the judiciary in the country, and then he or she have to have such weapon in his or her rights. This is completely against international standards. The Venice Commission recommended deleting this competence. In Macedonia, our Minister of Justice does not have any competence to interfere in the prosecutorial work, which is good. I think it's good. But the problem is that public prosecutors are blind for the corruption in the judiciary, and no other power has any competence in this area. And that leads to a serious disappointment of the citizens in the efficiency and functionality of the institution. To conclude, I believe that normative universalism and migration of constitutional ideas lead toward development of constitutional law. But also, I think that local, national context in constitution building and creation of legislation should not be underestimated. Thank you for your attention.
Thank you, Professor Deskowska, for your discerning speech, discerning observations with reference to the expression that you stated, that comparative law is troubling. That actually reminds us how there is a felt need to actually invigorate our ideas in order to discern national laws in a comparative sense. You also referred to the Trump's case with reference to whether presidential immunity shall be granted or shall not be. And last but not least, a nice reference was also made to the Venice Commission and the work that is presently doing or presently conducting, and especially with reference to striving to consolidate the judicial governance, especially with reference to the appointment of the judges and the powers alike. So very nice observations indeed. We have come to know a lot about the Venice Commission and what the Venice Commission is doing with reference to promoting a law in a comparative sense, especially constitutional law in a comparative sense. Third, in our keynote session, we have with us Mr. Hemang Shah, Director of Engineering, Qualcomm India, Private India Private Limited, Bengaluru. Now, we have heard persons from the academia. Now we are going to listen to someone who represents the industry. And if I may be allowed, let me introduce him to this august audience. Now, Dr. Hemang Shah is director of engineering at Qualcomm India, based out in Bengaluru, and he leads engineering engagements in India, and he also serves as an intellectual property mentor for startups, and guides them in their intellectual property strategies, and including their product designs, and how AI may be leveraged. So a lot of it, which is in the offing right now, especially vis-a-vis the field of intellectual property. And he also works in areas which includes agri-tech, IoTs, Internet of Things, robotics, automotive, and medical technologies. And as an innovation evangelist, rather a tech transfer evangelist, he frequently engages with the ecosystem, including with people who are starting who are in startups, or who are in the industry or in the academia. And he has also been granted two US patents, and there are more than 10 patents which are still pending with the US and other international patent offices. So we are eager to hear from you, sir. And we are eager to hear an industry perspective of comparative law. Thank you so much. Floor is yours.
Thank you, Dr. Banerjee, for the very kind introduction. And thank you to the entire team at Amity for inviting me here and making a part of your program. As Dr. Banerjee had shared, I'm deeply involved with the Indian startup ecosystem. My journey with them started in the year 2016 or so. So this is when we had, India had announced the Digital India mission. The Make in India program was well announced by then. But there was an interesting gap, right? So when you think of how, let's say, a country like China has advanced and continues to be a very strong player in the innovation ecosystem today, it is because they have a very strong manufacturing ecosystem, but they also have a very strong design ecosystem. What this means is that, let's say you take high-tech products such as you're making phones, for example. You have, of course, you need factories that can manufacture and assemble these phones. But you'll also have new players that want to design their own devices. They want to, let's say, make their own custom modifications to camera. They want to enter the market in a unique way. If you have an ecosystem where the design houses or the R&D teams are sitting right next to manufacturing, your time to market can become much faster. So with Make in India, we were of course going to address the manufacturing space, but back in 2016, we saw the potential in Indian startups specifically, and we announced programs over there. So today I thought of sharing some highlights with you. Now, if I can I should be able to share my screen. Okay. What I request is for you all to just confirm if you can share my screen. If you can see my screen, my bad.
Yes, Dr. Shah, yeah, it's visible.
Sure. So I thought of covering innovations that we are seeing in the deep tech startup ecosystem today. And the idea here being that, IP plays a very crucial role, but IP is not the start point. The innovations are, the products are, the startups are the origin point, and IP is a very natural outcome. So that's how you need to think about it. It's a homogeneous cycle that we have. Now, first, for those of you who are not familiar with Qualcomm, we are a company which was founded in the mid-80s by a professor and about 6 or 7 of his friends. In fact, those who in the engineering space will recall studying Viterbi coding. So Dr. Irvin Jacobs, Dr. Viterbi, and the co-founders saw that the phone technology that was being used at that time, the communication technology, was inefficient. And they set about working on something which is called as CDMA, and that eventually became the building blocks for our further future technologies, such as 3G, 4G, 5G, and now soon enough we'll have 6G. But at the heart of it, we are a system-oriented company. Now, what does this mean? This means that yes, we will innovate on the latest communication standard. We have teams that have been working on 6G for the past couple of years already. But when it comes to actually using the products, that is one part of the equation. We need, of course, our devices to run for much longer time without having to recharge them. So power management plays an important role. You got to have good location accuracy. I mean, imagine we all are ordering from Swiggy, Zomato day in, day out. And yet, I mean, it's our flat number which identifies. Soon enough, it will be, the location accuracy will be down enough to less than a meter, such that, let's say, your device or your home itself or that device location may be the factor that determines where that package should be delivered. Security, machine learning, those are all important areas. So as a company, we are innovating across the verticals. It's a deep effort on R&D, deep commitment to much further looking technologies ahead. As an investment, the company has spent more than $85 billion cumulative towards R&D efforts, and this innovative work has resulted in a patent portfolio of 140,000 patents and counting. Now, when working with the Indian startups, I'm showing you a brief snapshot of the startups that we have worked with. Now, these are the ones that have come through our program called as the Qualcomm Design in India Challenge. This is a program which works with, I would say, seed stage startups to pre-Series A. These are funding level wise. Their funding level is not the qualification criteria. What we look for is, do they have a working prototype ready at that point of time? Do they have a team which is ready? And these tend to be the teams that have actually crossed the seed stage of funding. So since 2016, we have incubated 101 startups. These startups are in the categories of health tech, smart cities, robotics, automotive, agri, wearables, green energy, 5G, fintech, and compute. Collectively, they have raised more than $250 million in funding. They are making their way across to the serious levels of funding stages as well as M&A exits. In terms of patents, which is what we'll focus on today, they have filed for more than 400 plus patents of their own. And they not only file in India, but they file worldwide. Because the market for their products, and I'll give you an example of what these products are. That market is not just India. They start, of course, solving a local problem around themselves. They start by entering the Indian market first, but soon enough, they are shipping global. And a number of them are qualifying for the central government schemes, which are central and state government schemes, which are supporting startups. How does this program work? I'm giving you this contour because, IP cannot be generated just by itself, and neither do innovative products, come about just like that, right? There is a process that we follow, and it starts with a rigorous selection process. So till date, we, to intake, these many startups, we have evaluated thousands of applications. From that, we select a pool of startups that enters a program. So typically for incubation, we select 12 startups every year. When we work with them, we try to get them, over a 9-month journey to enter the rapid prototyping phase. And this is enabled by providing deep technical guidance and, working with them in our state-of-the-art laboratory in Bangalore. We guide them, we consult them on IPR and why they should be mindful about it. We also provide them business mentoring. This program runs in a competition format, so there are top 3 winners. And after they complete our program, they are in touch with us. We have very strong alumni connects. Which are the kind of startups we are looking for? Very simply, startups that are creating products that require connected hardware, that require artificial intelligence and machine learning on the device itself, and who are eager to patent. So these tend to be product-oriented companies. Everything in this program is equity free, including the cash prizes. So there are no binding agreements, no binding arrangements to Qualcomm. It runs in an equity-free format. Our corporate ventures team does get visibility into these startups, and so later on, if they do decide to invest, that is a separate discussion. I want to give you a glimpse of the products which are being created. So on the top, I'm showing you this aeroplane-looking drone. This is made by a company called Tech Eagle, which won our last year's challenge. What Tech Eagle is doing is that they are deploying these drones to carry critical supplies, such as medicines, in hilly and remote areas of Arunachal Pradesh. In those terrains, transporting things through road takes multiple days, anywhere from 3 days to 7 days, depending on the road conditions. Instead, what Tech Eagle is doing is that they are building like an infrastructure for drones so that they can fly more than 100 kilometers. In between, if they have to restop, get their batteries, changed, swapped, they may have these between stations, and then it goes on to the next, journey onwards. So because they are long range drones, last year they had working demonstrations of 100 kilometers range with payload. They are working towards a 300-kilometer range. So imagine the impact that a product like this can create. And they are using 5G connectivity to establish communications with the drone and provide accurate guidance. Here I'm showing you a product which is called as Emfolio. It is made by a company called Black Frog. Black Frog is headquartered in Bangalore. And the founder, Mayur Shetty, he saw a problem that when polio vaccine providers, you have these vaccination camps in remote areas, when these folks would go, transporting the vaccine, he saw that they were being transported in sometimes things like ice boxes, where we carry for picnics, we carry ice boxes to keep our drinks cool. Those were the ice boxes in which vaccines were being transported. Now, this gives you a couple of problems. Firstly, in our country where heat and humidity are high, the ice melts, so the temperature of the vaccine is not maintained. Sometimes that is overcompensated by adding things like dry ice, which actually cools down the vaccine below its working temperature threshold, and so that effectively also renders the vaccine useless. So Black Frog created this first WHO compliant refrigerator, rather a temperature control chamber for the transport of vaccines. And this is an ergonomically carried bag, which helps the workers even transport the vaccines and test samples to remote, again, hilly areas, both in the Northeast, but across the rest of the country. And they are the ones that are generating just a lot of demand, because it's such a powerful product. And lastly, I want to discuss this example. You're seeing this XR headset. It's by a company called Ajna Lens. Ajna Lens is using XR, which is a combination of augmented and virtual reality, to train people for applications such as welding, spray painting. Now, imagine I want to become an automobile painter. I want to work in a large car manufacturing facility. And India has an amazing demand for car manufacturing, right? So in these factories, if I want to become a spray painter, I actually have to go through trainings at ITI institutes. So they'll give me some paint guns. I'll be working on that. I'll be using a lot of chemical as I build my proficiency level up. Before I am allowed to work on an actual factory, I have wasted a lot of chemical. What Ajna Lens has done is that they have taken actually certified spray paint cans. They have modified them with sensors which sense how you are orienting your hand. They put sensors which sense how much pressure you're putting on that. Because sometimes for a light coat, you will press it gently. For a heavy, thicker coat, you will press it harder. And of course, you can put the spray paint, the can itself, because muscle memory is a good part of your training regimen. Now, all this is connected to your XR headset. They have their own custom software which they have written, that will grade you as you start, doing your training. Through this approach, Ajna Lens has trained more than 18,000 technicians in areas such as spray painting, welding. They're getting good demand from other vocational skills. People that want to operate things such as forklifts, even defense and navy, operations. They have a lot of training. So getting access to the equipment is not easy for everyone, but through their equipment, through their setup, you can be trained much faster. So you can see these are all innovations, very cool products which are coming out of India, and very naturally there is a tremendous scope for intellectual property rights, and that's why we have all these building blocks which are set up to ensure the success of the startups. We also have programs to support early stage startups. So in our program called Queen, which stands for Qualcomm Women Entrepreneurs India Network, we have so far mentored 33 women-led startups. Last year, we also announced the Qualcomm Semiconductor Mentorship Program. This is to, again, mentor and support semiconductor product startups. So in India, we have a large India Semiconductor Mission, which is going to lead to a wave of startups and companies that will do semiconductor manufacturing. And so this is a way to get an early look at them and support them in their journey. Now, these programs are seeing startups which have had amazing traction. So we have had a couple of startups which have been selected for the Ministry of Electronic and IT's Design Link Incentive Scheme. They're winning awards. Very cool startup called CaneBot, which is doing which has made an IoT equipment for automated sugarcane juice vending. Okay, so it will store sugarcane stocks. It will pick it up depending on the flavor you want, whether you want sugarcane juice, whether you want sugarcane with lime, lime plus ginger, all combinations, completely automated. And in fact, the Karnataka State Cricket Association selected this startup to deploy their machines at the Bangalore Stadium for all India Cricket World Cup matches. So it's an exciting time to be here in India. And again, the building blocks for such programs are a bit different, where one-on-one mentorship is provided. Selecting the best leader from our company to be paired with the startup. So that's the direct mentor. But we also have mentorship across different verticals through subject matter experts and through master classes on topics such as IPR, product management, marketing, scaling, and so on. And we also realize that for these startups, building a strong network is a critical aspect of their journey. So we have sessions and programs that allow them to build that, and also providing them a lot of spotlight. So how does intellectual property really help them? So there are some strategic ways in which IP has to be looked at. And this is a good aspect of where most of our mentoring focuses on. Because many startups, so unlike you, which is an informed audience that understands IPR, startups may not understand all the benefits. So some of the benefits, the clear ones, are that if you protect your inventions through IP rights, you can stop your competitors from copying your innovations. That's one that we all know of. But there are other advantages. These days, investors are looking at the quality of, say, IP portfolios, not just patent portfolios, but every IP right which is applicable to the startup. And if the startup has a good portfolio, they're able to command a much higher valuation. If you travel in countries, such as the US, where I spend a fair amount of my time there, even a simple coffee cup, if you look at the cardboard packaging on the side, you will see that they are listing anywhere from 5 to 10 patents sometimes. Something which doesn't have anything to do with coffee, right? But that cup itself keeps that drink warm. It keeps spillage from happening. You are consuming an innovative product. So that enhanced reputation works very favorably in, for your company and specifically for startups. You can do cross collaboration. You can, of course, take legal action against someone that does not respect your intellectual property rights. But the most important one, in my opinion, also is that these are assets being created. And quite a few times, we have small companies, SMEs and startups that think of IP as a cost function, because they are paying for agents, they are paying for legal services. So they think that it's a cost, it's money that is going out from my bank account. And they're right. But in exchange for that, they are getting IP rights, they're getting assets. And that's the mindset change which needs to happen. And that asset can allow you to monetize the IP and you can earn additional revenue from it. So how does one go about building an IP strategy? And for some of you who will enter this domain, I request you to inculcate this IP strategy mindset and even teach that. So it firstly starts by creating a system, because you need a system to collect ideas. We spend a lot of time brainstorming. Like if you hold a brainstorming session today, you could generate as many as 100 ideas. But if they're not tabulated anywhere, you will lose track of them. We have so many ideas, whether it's through our runs or through in the shower or wherever. But if we don't log them, that's an idea which is lost. It's money wasted or left on the table. So create a system. Create a system to identify these ideas. And one easy way of doing this is look at your 3-year or 5-year roadmap. What are the kind of products which are going to be created? What kind of features or differentiating elements will be required to make those products win in the market? And that will influence your system, and that will also influence how you carry out R&D. Now, protecting the IP rights through the use of tools and processes, that's a call you can take. Do I want these to be done in-house, or do I rather work with a firm or an agent that can do it for me? A good portion of my time goes in convincing the startup founders that the initial creative energy is always going to be high with the founding team, which is the CEO, the CTO, and that function. But those folks are oftentimes traveling. They are meeting investors, they are going to competitions, they are trying to sell their product, their business meetings, and whatnot. While they are away, what happens to the innovation cycle? If their employees are trained, that cycle will continue. And eventually, this IP is an asset mindset, that how can we get the maximum value out of the IP rights that we have. Now, we have some international participants, but also for the rest of the audience, I thought of highlighting some startup IP schemes, which have been introduced by the government of India. Now, there's a scheme specifically called as the Startup Intellectual Property Protection Scheme. Now, this scheme provides a few clear, amazing advantages. Okay, the first one is that anyone who's filing a patent as a startup, okay, so they have to register at Startup India website and they get a DPIIT number. If that is attached to your patent application, it is considered for expedited examination. And through this, we are seeing really fast examinations. Firsthand, I know of one of the startups that came in our program. They got their grant in 7 months. Now, this is not a benchmark, but the government has publicly said that they want to drop the evaluation time to 18 months. You get an 80% reduction in the filing of the fees. And finally, you get access to patent and trademark facilitators. These are folks that will work on your patent and trademark applications, but they'll build the government. So the mindset that we need to change is that, yes, the initial innovation happens in India, but the business growth, the market, everything is global in nature. And if you have innovations, there's a strong M&A impact. The top recommendations for innovators and for folks who will enter this space is inculcate a mindset of innovation, have periodic IP reviews. Just one patent, just one trademark will not cut it. You actually need a portfolio of IP assets. And later on, I will share a program with you, which will talk about these in more detail. It's a program we have launched in partnership with DPIIT and LU Delhi. It's a completely free program for startups, for SMEs, and for everyone actually. It has been taken by 7,000 plus learners. And this is to inculcate this IP mindset. And it has case studies which talks about what will you do in a situation that a startup is encountering. So I wanted to leave these thoughts with you, and I thank you for having me here.
Thank you, Dr. Shah, for those words. Actually, we learned a lot about technology and law. It's said that in law, as we say, it's a very difficult marriage between technology and law. However, the innovation strategies that you've adopted and the metrics that you have referred to in promoting connectivity, system design, and computing using artificial intelligence, that's a wonderful experiment that you are hopping on, and extending the startups, extending promotions in IP. It actually leaves a lot of room for the interplay of laws, for example, healthcare laws in that matter, or laws concerning drones, or regulating drones to be precise, or regulating the use of robotics. So yours is it marks an inflection point in our academic debate a bit, but the observations are really interesting, and it was a learning session for all of us. And we believe that in the future times to come, technology and law, the comparative element is still in the offing. So we are trying to do, many of us are trying to do comparative analysis of technology and IP laws. And this provides your deliberation provides a lot of room, a lot of scope for those researchers actually who can extend beyond borders and think about having new startups in cognizance with the other laws that operate in other jurisdictions, both civil and the civil law jurisdiction and common law jurisdictions across the world. Thank you so much for your insightful observations on technology and law, especially focusing on the IP metrics. We have next with us Dr. Ivan Satriawan, professor, who's a professor in the Universitas Muhammadiyah Yogyakarta, who is from Indonesia. And because of some reasons, we would have a recorded lecture of Dr. Ivan, and I would request the coordinator of this, the main coordinator of this event, Dr. Rupendra Singh, to please come up with a recorded version of Dr. Ivan.
I hope the screen is visible, Dr. Razak.
Yes, sir, it is visible.
Dr. Ivan is there in the meeting only, but he will take the question answers, and in the meantime will play his lecture.
Right, sir.
Okay.
University, India. Honorable Dean, Edith Cohen Law School.
I hope it's audible also.
Singh, all the committee,
yes,
member and participants. Thank you very much for allowing me to present my paper on the challenges of selection mechanism of the Constitutional Court Justice, lesson learned from Indonesia, South Korea, and Germany. It is a great honor for me to share my result of research for the 2 years research regarding this topic. And of course, I will be happy if the professor here, the participant, would give also the comments and questions on my presentation. So the title of my presentation is The Challenges of the Selection Mechanism of the Constitutional Court Justice. So we did research on Indonesian case, South Korea, and Germany. And actually, we have also produced journal and also book reference on based on the result of this research. Ladies and gentlemen, allow me to start my presentation by introducing one of very hot issues in the last year in Indonesia, that when there is a very serious discourse among the constitutional law expert in Indonesia when our parliament fire or intervenes the independence of the constitutional court by what? By firing one of the justice of the constitutional court. The name is Justice Aswanto. So basically, the House of Representatives or our parliament does not have authority to fire any justice, but that's the fact that did by the parliament. They fired one of the justice of the constitutional court that they proposed to the president. So this case, of course, become very controversial in Indonesia because it's beyond the reason and the logic, as the parliament claimed that Aswanto, who was proposed by the parliament, has criticized and nullified many laws enacted by the parliament. So this is one of the controversial case. And after that, the parliament also proposed a new justice, right, to replace the position of Justice Aswanto with the abnormal procedure to appoint the new justice. So, ladies and gentlemen, so if we observe from these two cases, we may highlight that there is always political tension between legislative and executive body on one hand, and the constitutional court on the other hands. So if you look at to the case of Indonesia, maybe we can say in the first 10 years of the establishment of the court shows that they have achieved significant contribution to uphold principle of constitution, to protect the constitutional right of citizen. But after 10 years, we may observe that there is a tendency of the politician topic. And this is my second slide that show basically in the first 10 years of the establishment of the Constitutional Court of Indonesia, mostly the scholar agree that there is the rise of the performance of the Constitutional Court because there are significant decisions related to the principle of equality, prohibition of discrimination, protection of the constitutional right of the citizen, and also at some times the court has given contribution to the limitation of human rights and principle of proportionality. And the third one is Indonesian Convention on International Human Rights. So based on its 10 years of experience, former Justice Marwarar Siahaan state that the presence of the Constitutional Court in a new democracy. So because at the time Indonesia called as a new democracy, as institution needed for the strengthening of democracy and human rights protection in a transitional period. So basically, after the political reform in 1998, and then followed by the fourth amendment of the Constitution, and then in 2003, we established the Constitutional Court. In the first 10 years of the establishment, the court has given significant contribution to be what we call is the guardian of the Constitution and also the guardian of democracy in Indonesia. However, if we observe for the second 10 years, so the first 10 years is my PhD dissertation, and now what I'm doing is my research is for the second 10 years. So if you look at some list of cases that happened in the Constitutional Court, we may look at that there is the fall of performance of the justice of the court. So, ladies and gentlemen, if you look at this, right? So there are some justices that involved in some what we call is a violation of code of ethics, bribery cases, right? So you can see this, there are 7 cases in court, and the case above shows that the Constitutional Court is experiencing serious decline in terms of the capacity and integrity of the justice. My question, right? The big question in this presentation is what was the reason behind this happen? What are actually the root of the problem that why there are many justice in the Constitutional Court involved in many cases of violation of code of ethics and also bribery cases. Ladies and gentlemen, allow me to summarize some root of problem of our Constitutional Court justices. The first one is based on my research. It shows that the Constitutional Court justices selection mechanism is not standardized. Okay. The second one is weak supervision system for the Constitutional Court justice, and the third one is low commitment of the government official to the Constitution, especially to the President and the House of Representatives. And number 4 is the power of civil society is not properly consolidated in monitoring the performance of the Constitutional Court. Ladies and gentlemen, my 2 years research on the selection mechanism of the justices in Indonesia shows that, as we know, we have 9 justices, 3 justices proposed by President, 3 justices proposed by the Parliament, and 3 more proposed by the Supreme Court. So basically, this model adopted the model from the South Korea, right? But the problem of our selection mechanism is each organ, they don't have a standardized selection mechanism, right? If you compare to the South Korea. So the president has their own mechanism, the parliament also, and also the Supreme Court, they have their own selection mechanism. So therefore, I conclude that this selection mechanism in the 3 branches of the organ is not standardized because if I can give you, for example, in the Supreme Court, there is a closed selection mechanism. So there is no sufficient consultation, there is no sufficient public hearing, or maybe we can say confirmation hearing that involve public participation to know more about the process of selection of the justice in the Supreme Court. And also, in some cases, the president, without having a confirmation hearing, suddenly proposed the new justice to the president. And in some cases also, the parliament also, without having sufficient fit and proper test or confirmation hearing, they propose a new justice. So if you look at to the list of cases that I mentioned before, mostly the justice that involved in the violation of the code of ethics and the bribery cases are the justice that had problem with the selection of selection mechanism. So it shows that having standardized selection mechanism is important to produce a better quality of the justice. So that's my first point. The second one is we have also weak supervision system of the Constitutional Court justice because so far we have only internal supervision for the justice. We have honorary council for the justice, but the composition of the judges for the honorary council come from 2 from the element of the Constitutional Court and 1 more from outside of the Constitutional Court. So this is the problem of our supervision, and therefore, in some cases of the violation of code of ethics, we could see that the punishment that given by the honorary council is not maximum, and it is not sufficient to protect the quality of the constitutional court justices. So that's the second point. And the third one is the law commitment of the government official, particularly the president and the house. In fact, I think, in my opinion, if the president and the house of representatives have full commitment to what to practice the principle of the constitution, to make sure that there is what we call is they they appreciate the independence of the court. The president and the house should try to constrain themselves to not interfere the independence of the constitutional court. And the last one is basically, in terms of democratic state, we need also the existence of strong civil society, because to some extent, in democratic state, sometimes the opposition is not quite strong, and sometimes also judiciary is has also become the threat for the people in power, and therefore we need also the support of the civil society to support judiciary and also to control people in parliament and the executive body. But this is the problem of the Indonesia, because during 10 years of the establishment, or more over 20 years, we observe that the role of the civil society is not quite proper to control the practice of the state. Ladies and gentlemen, this is the picture shows that the process of the selection mechanism in parliament, right? So you could see that the process, the down registration, and then there is actually the written test and the presentation. But if we could see here, there is no what we call is confirmation hearing process that is more sufficient, right? And this is also the selection process through in the Supreme Court, because they have also authority to propose 3 justices. And the problem of the selection mechanism in the Supreme Court is they use a closed process of selection, and it is a selection process by the president. And if you observe the process of the selection through the president has no standard. Sometimes they set a committee, and then there is a fit and proper test, but sometimes the president did not use that mechanism. They appoint directly the person that he or she like. So this is the problem that I call in the beginning, that there is no standardized selection mechanism. And if we compare to the selection mechanism in South Korea, we could see that, yeah, even actually the justice also proposed by 3 branches of the organ. The same happened in Indonesia, but you can see here that in South Korea, all candidates from National Assembly, from the Supreme Court, and also from the president, all candidates must attend what we call confirmation hearing by the National Assembly. So we could summarize that the process of the selection of the justice in South Korea, all candidates must attend the confirmation hearing, and therefore there is what we call is transparency and accountability of the process. And by having this transparent and accountable process, they may produce a better qualified justices. So I think if we compare to Indonesia, the good point from South Korea is they have standardized process of selection by having confirmation hearing in National Assembly or Parliament for all candidates from the 3 branches. So I think that's a good point from South Korea. And this is the function of the confirmation hearing. If I'm not mistaken, in Korea they have what we call is Confirmation Hearing Act that adopt from United States of America. This confirmation hearing promote legitimacy of democracy, put the principle of separation of power into practice, ensure the nominee's job suitability and integrity, satisfy the public rights to be informed, and facilitate harmony and cooperation in the organization of state agencies. And the last one is selection mechanism of constitutional court justice in German. So in German, the selection process of justices involve the two bodies that are Bundestag, the German federal parliament, and also Bundesrat. So the uniqueness of the Germany system is they put the power of the selection mechanism of the justice lies in the hands of the two organs, that is Bundestag and Bundesrat. So if you compare to Indonesia, the selection also involved the president and the Supreme Court. Ladies and gentlemen, I think to end my presentation, allow me to explain or to highlight some point regarding to this issue. So Indonesia still need to strengthen the selection mechanism by making particular regulation like the compulsory of the candidate to attend confirmation hearing in parliament, and therefore by having this kind of mechanism we may have a better quality of justice in the future. If we see the lesson learned from the South Korea, I think the confirmation hearing is the strength of the selection mechanism of South Korea. And also in Germany, because the selection mechanism lies in the hands of the parliament, both in federal and in the state. So it means that also they have also a good principle of transparency and accountability in the process of selection of mechanism. I think that's my my point in the keynote, and allow me to close my presentation by stating that the strength of the Constitutional Court lies in its ability to guard the limits of power, balancing the branches of the government so that they do not exceed the authority granted by the Constitution. The dream of the Constitutional Court as the guardian of the Constitution can only be realized if the Constitutional Court is filled with justices who are statesmen, have the best capacity, and also integrity. Thank you very much. Good day, everyone.
Thank you, Professor Satriawan. I beg your apology for not introducing, since we were not aware whether you would be personally present. So before I wind up Professor Satriawan's observations, allow me to introduce Professor Satriawan. He's an associate professor in the Universitas Muhammadiyah Yogyakarta, Indonesia. His areas of expertise include human rights, constitutional law, constitutional politics, and philosophy of law. He has quite a few papers published in various law journals, and he is pivoting quite a few research projects, especially focusing on the judicial systems. Now, winding up the observations of Professor Satriawan. Professor Satriawan rightly has pointed out one of the major issues facing the society in general, and some of the societies in particular. So he has made a wonderful comparison between Indonesia, South Korea, and Germany to underscore the relevance of adhering to certain Grundnorms, certain constitutional principles, whether it is with reference to appointment of judges or otherwise. So he had also he's also taken references to an example wherein one of the justices was removed by the Parliament of Indonesia, and the president had appointed another person in his space. So, of course, it gives all of us a feeling that the right to equality, and read with the prohibitions of discrimination, is they are largely curtailed, especially in the Indonesian perspective. despite the fact that Indonesia is committed to the international human rights norms. And the fall, you'd also refer to the fall of performance of the constitutional courts, especially in the recent years, post 2010 through 2023. And we all look forward and we all think that that comparative constitutional law will come up to its will actually take Indonesia to higher standards in terms of commitment and in terms of revamping the judicial processes. Over to now we have with us the next speaker, Professor Dr. Shailesh N. Hadley, the Registrar, Dharmashastra National Law University, Jabalpur. Now, Professor Hadley was a panel advocate, and he dealt with the matters relating to several players in the industry, including banks, Mahindra Finance, HDFC, and City Finance also, to name a few, wherein he acted as a sole arbitrator. And he has an astounding number of arbitral cases being decided under his aegis, about more than 800 cases being decided, and he has about 12 years of teaching experience, and he is presently serving as the registrar of the Dharmashastra National Law University, Jabalpur. I would request Professor Dr. Shailesh N. Hadley to take over the stage, please. Professor Hadley, are you around, please?
Okay, done. Hello.
Yes, sir, you may proceed. You are audible.
Yeah. I'm audible, right?
Yes, you are audible
Yes,
as well as visible, sir.
Okay, okay. Fine, just a second. Okay. Good afternoon, all. At the outset, I would like to congratulate Amity University for conducting an international conference on the competition law. And I appreciate the teamwork of the law school, wherein they have managed to invite all the distinguished guests from the nooks and corners of the world and to speak on various topics. And especially to Jayanara, Matthew, and Rupindra, and the Dean and the Director of School of Law, Amity University, for this good initiative. And my topic for today is mediation laws, a comparative study between India, America, and Australia. The conflicts are inherent in human interactions, whether personal or commercial. They encompasses three dimensions: the individuals involved, the process they follow, and the underlying issues at hand. While disputes are natural occurrences, their resolution methods significantly impact the outcomes. Two primary approaches exist: adversarial method, such as litigation and arbitration, and non-adversarial methods like mediation and conciliation. For every nation grappling with the backlog of pending cases is a challenge, and the alternative dispute resolution is indispensable. ADR methods offer expedient, cost-effective resolutions, easing the burden on the overloaded judicial system and resolving international disputes in much more amicable and faster way. ADR is an alternate dispute resolution, and there are 4 to 5 methods of ADR. Some of them are negotiation, conciliation, negotiation, mediation, lok adalats, and arbitration. These are the various methods wherein the disputes can be amicably settled. Conciliation is a method wherein a person intervenes and explains the situation to both the parties and try to get that particular things settled. Then negotiation is a way wherein the parties try to negotiate in between them and to resolve the disputes amicably within them. The mediation is a kind of a thing which is there in existence from the timely memorial, and it is a way wherein a third person facilitates the negotiation and tries to strike a balance between both the parties and to come to a conclusion. Apart from this, arbitration is a process which is a parallel body to the courts, but it will not be similar to the courts in all angles, but certain discretion has been provided under the ADR, that is Arbitration and Conciliation Act, or the arbitration, wherein the third neutral person tries to adjudicate and provide the solution. Mediation is one of the methods of ADR which proposes a voluntarily and informal process for the resolution of disputes. It is defined as mediation is a collaborative dispute resolution process where parties seek to achieve mutually agreeable settlement with the guidance of a neutral third party known as mediator. The mediator facilitates and constructive communication and negotiates the settlement between the parties without possessing the authority to enforce or impose a resolution upon them. Mediation practice in India. In India, mediation has ancient roots with practice like panchayats facilitating community-based dispute resolution. During British rule, traditional mediation declined in favor of adversarial litigation. But later on, Section 89(1) of the Civil Procedure Code 1908 introduced provisions for the courts to suggest mediation as an alternate dispute resolution method. The legal framework paved the way for the establishment of mediation centers across the country, aimed at facilitating amicable resolution and reducing the burden on the judicial system. After independence, many legislations also suggested mediation as a form of dispute resolution. Dispute this private mediation initiated by the parties themselves lacked proper structure and legal recognition, and only court mediation was in practice to take care of the issue and to encourage the institutional, private, and online mediation. The Government of India has come up with the Mediation Act 2023 last September. Earlier to this, the mediation was in existence, but it was restricted to the family courts, wherein the matters related to the family matters were uh, the forwarded to the mediation center for the purpose of mediation, and there it would have been mediated by the trained mediators. The Mediation Act of 2023 marks a significant step forward in the Indian legal landscape by prioritizing mediation as a means to resolve dispute effectively and efficiently. Its primary objective is to promote and facilitate mediation across various sectors, including institutional, online, community mediation. One of the noteworthy aspects of the Act is its broad definition of mediation, which encompasses pre-litigation mediation, online mediation, community mediation, or conciliation. As a result, the distinction between the mediation and conciliation is eliminated, allying with global norms where these terms are often used interchangeably. This trend of the Arbitration and Conciliation Act redolent prompting the Mediation Act to propose the removal of conciliation provision from the Arbitration and Conciliation Act. The Act applies to the mediation conducted within India, covering dispute where the parties resides are incorporated or conduct business in the country. By virtue of Section 5 of the Act, now mediation can be initiated in three ways. First, by court-referred mediation under Section 89 of Civil Procedure Code, and thereafter provisions of Mediation Act 2023 will apply. Secondly, irrespective of any mediation agreement, the parties may voluntarily and with mutual consent refer the dispute to the settlement by mediation before filing any case of civil or commercial nature in any court. Lastly, the Act does not affect the compulsory pre-litigation mediation under the Commercial Court Acts 2015. It also empowers courts to issue interim protection orders to safeguard parties' interests during the mediation process. Parties have the authority to choose their mediators, ensuring the impartiality and fairness in the mediation proceedings. The Act mandates that mediators disclose any potential conflict of interest and maintain confidentiality throughout the mediation process. As per Section 27 of the Act, once the mediation settlement agreement is reached, it becomes final and enforceable as the court decree, providing parties with the legally binding resolution to their dispute. And in the present Act of 2023, there is a provision for registration of the settlement before the competent authorities. And for this particular purpose, mediation commission has to be constituted for looking out all the activities under this particular act. Overall, the Mediation Act 2023 represents the significant legislative efforts to promote mediation as a viable alternative to the traditional dispute resolution methods in India. By embracing mediation, the Act aims to expedite the resolution of dispute, reduce the burden on the court, and foster more collaborative approaches to conflict resolution. Mediation practice in America. In the United States, the roots of mediation can be traced back to the Native American disputes resolution practice and early court-sponsored mediation introduced by the English settlers. Its popularity grew in the early 20th century due to the labor disputes by the late 1970s and early 1980s. Mediation-related legislation began to emerge, leading to its widespread use of the civil and administrative agency cases today. The United States has the robust system of resolving the conflict through the mediation and arbitration, driven by the public policy supporting alternate dispute resolution to reduce the court's burden and cost. By the mid of 1980s, lawyers and the state bar associations professionalized mediation, establishing training standards and ethical guidelines. This led to the lawyers incorporating mediation to their practice, further solidifying its role in the legal system. Today, mediation is the primary ADR model used by the United States courts, with federal agencies also embracing ADR in resolving various disputes. Dispute mediation in United States lacks a central governing regulatory body. Instead, standards are set by respected associations like American Bar Association and American Arbitration Association. Each state has its laws governing mediation, which have evolved over the time. In 1998, United States Congress passed Alternate Dispute Resolution Act mandating federal trial courts to implement ADR and granting judges the authority to refer cases to mandatory ADR procedures, including mediation. The United Nations Convention on International Settlement Agreement resulting from mediation, adopted in 2018, is a significant step towards facilitating cross-border enforcement of mediated settlement agreements. In the US, there are numerous professionals organizations of mediators, and each state has its standards and requirements for mediators. Accreditation can be obtained online, making the mediation accessible to the individuals with diverse backgrounds. Court-appointed mediators may have higher qualification such as JD or relevant graduate degrees, depending upon the state. Additionally, the mediators are often granted immunity for civil liability for misconduct during the mediation proceedings, further enhancing the credibility of the mediation process. While the United States lacks centralized legislation specifically dedicated to the mediation, it boasts a resilient and flexible mediation system that adaptly caters to the diverse need of its populace, offering practical alternatives conventional litigations. Mediation practice in Australia. Mediation settlement in Australia has rich history dating back several decades. The country has long tradition of utilizing alternate dispute resolution methods, including mediation to resolve conflict outside of the formal court proceedings. The use of mediation and the ADR techniques in Australia can be traced back to the early 20th century community-based dispute resolution process influenced by the indigenous Australian traditions were prevalent in rural and remote areas. In later half of the 20th century, there was a growing recognition of the benefits of the mediation in the Australian legal system. Various initiatives were undertaken to formalize and institutionalize mediation process, particularly in the family law dispute. The enactment of legislation at both the federal and state levels played a significant role in promoting mediation settlement in Australia. The Family Law Act 1975, for example, introduced mandatory mediation for family law matters, encouraging parties to resolve disputes through mediation before resorting to the litigation. Australian courts began incorporating mediation programs into their operations, offering court-referred mediation service as the means to resolving dispute efficiently and cost-effectively. This approach has been widely adopted in civil, commercial, and family cases across the country. Section 27D of the Commercial Arbitration Act 2017 also provides for the mediation proceedings if arbitration agreements provides for the mediation proceedings, hence promoting the quick resolution. Today, mediation settlement countries continues to play a vital role in Australian legal system, offering practice a flexible, collaborative, and confidential process of resolving conflict across a wide range of contexts, including family, commercial, workplace, and community disputes. In conclusion, the comparative analysis of the mediation laws in India, Australia, and America underscores the global trend towards alternate dispute resolution. While each country has unique legal framework, mediation has emerged as preferred methods of resolving the dispute efficiently and collaboratively. From the recent legislative development in India to the long-standing practice in Australia and United States, mediation continues to play a vital role in promoting access to justice and elevating the burden on traditional court system. Most of the nation, even after Singapore Convention mediation in 2019, still lack a legal framework on mediation for the cross-border disputes. Thank you. Thank you.
Thank you, Professor Dr. Shailesh Hadley, for your presentation and for providing us an opportunity to know the comparative on a comparative note the positions in terms of mediation on a broader basis in terms of alternative dispute resolution, the position that is prevailing in India, in the United States, and in Australia. And you have spoken about the mediation centers and have referred to the Mediation Act 2023 and how the Mediation Act in India has been a significant move, a significant legislative effort towards promoting a different kind of a legal system. And rightly so, the analysis, the comparative analysis is very, very significant because possibly time is ripe that on an international comparative note, we move away from the formal court system to an informal system wherein justice is not delivered on an adversarial note, and the people sit together and commissions are formed or committees are formed, and justice is delivered, and that too in no time. So it will also save a lot of time for the courts. Without much ado, I go on to the penultimate speaker of this keynote session. We have with us Professor Catherine Valk, Professor, University of Toronto, Canada. Now, Professor Valk is a professor at the University of Toronto, Faculty of Law. She has been a member of the International Academy of Comparative Law and has acted on several occasions as the National Reporter for Canada to the Congress of the Academy. Her 2018 book on comparing law, comparative law as reconstruction of collective commitments, which was published by the Cambridge University Press, strives to draw a legal theory to develop an interpretative conception and of an analytic framework for comparative legal studies. And apart from that, she has also worked on similar book projects, and a new book. I don't know whether the book has already been published, and the 2021 book is also in the offing. And Professor Valk is also the co-editor of the forthcoming edition of the Elgar Encyclopedia of Comparative Law. So it would be a great opportunity to learn law on a comparative note from Professor Valk. So over to you, Professor Valk. Thank you.
Thank you. Can you hear me?
Yes.
Can you hear me? Yes. Excellent. Okay. And I'm supposed to be able to share my screen. Let me give it a try. Can everybody see that? Yes?
Yes, ma'am.
Excellent. Okay, so let's. So I want to start by thanking, of course, the organizers of this great conference, Amity Law School and the School of Business and Law of Edith Cowan University and its organizers for putting this great event together and for extending this very kind invitation to me to participate in it. It's a real honor to be among you today. So modalities of comparative law. Well, the modalities of comparative law, of course, vary depending on the approach that one takes to comparative law, and thus also on the objective that is being pursued, on the reason that causes one to want to compare laws in the first place. Indeed, different objectives or reasons naturally motion to different methods, and hence also to different modalities. Now, among the different approaches that have been deployed by comparative lawyers over the course of the last few decades, the most prominent arguably are the two known as functionalism and cultural expressivism, or just expressivism for short. We could also add to that list critical comparative law and interdisciplinary comparative law. I will say more about each of these four approaches in a moment, but it's worth noting at the outset that the latter two, critical comparative law and interdisciplinary comparative law, really belong to an altogether different category than functionalism and expressivism, an altogether different epistemological category. That is because whereas functionalism and expressivism both adopt an internal standpoint on comparative law, the standpoint of those who actually do the comparative groundwork, critical comparative law and interdisciplinary comparative law stand outside that groundwork to observe it and comment on it from a distance. So they engage comparative law from the perspective of an external observer, not that of a participant in the discipline. My remarks today focus on the first category, that which gathers functionalism and expressivism, thus on these internal approaches to comparative law. The reason is quite simply that that category tends to be dismissed as academically unworthy. Indeed, comparative law groundwork is often derided as being devoid of intellectual substance, as a conceptually random activity akin to stamp collecting or paint by numbers. All that comparative lawyers would do, according to that dismissive view, would be to compile long lists of rules from different legal systems and lay them side by side, a bit as do stamp collectors or cricket statistic hoarders. And we would therefore have no choice but to move beyond comparative law itself in order to come across anything interesting, anything worthy of academic discussions. And academics have accordingly tended to adopt an external perspective on comparative law, either to criticize it as the vehicle for post-colonial hegemony or economic imperialism or whatever else that's critical comparative law, or else they have looked at it through the lens and approach and analytic frameworks of other well-established disciplines, sociology, philosophy, anthropology, etc., with a view to building new, if interdisciplinary, knowledge about law and legal systems. Now, don't get me wrong, I would be the last one to deny the value of such critical and or interdisciplinary work on comparative law. Quite the opposite, in fact. There is no question in my mind that that scholarship has been invaluable for honing our collective understanding of comparative law, for sure, but also of law and legal systems writ large. My only point today is that it is also possible to say interesting things about law and legal systems and society at large, in fact, from an internal perspective, from the very same perspective as adopt the legal actors, legal practitioners, judges, scholars operating within those systems on a daily basis. That is actually the central point of my book, which was very kindly mentioned just now in the introduction. That point being, in short, that the internal and external perspectives on comparative law are not mutually exclusive or even competing with one another, and that there is therefore no reason to think that one is to be preferred to the other. Rather, the internal and external perspectives aim to build different kinds of knowledge that, far from being mutually exclusive, in fact, complement one another very nicely. So I will focus on functionalism and expressivism, not because I view them as somehow superior or more important than critical and interdisciplinary comparative law, but only because I view them as equally important, which equal importance has tended to be obfuscated, if not squarely denied. Okay, so what can we say that might be interesting about functionalism and expressivism? The first thing to note is that these two approaches tend to be viewed as mirror opposites of one another. And in some ways they are. As its label suggests, functionalism focuses on the function of legal rules, their function as instruments designed to address pointed social problems. To be more specific, functionalism in comparative law focuses on the common function played by legal rules in all legal systems, their common function as tools designed to respond to a large set of social problems that happen to be quite similar across legal systems, right? All legal systems have to deal, at least on some level, with situations of theft, trespass, competition issues, people not honoring their promises. So comparative lawyers who self-identify as functionalists naturally tend also to fall among those who aim to harmonize law across legal systems. They tend to be legal harmonizers. The focus on what legal rules have in common, the common problem-solving function, makes it possible to bring all the rules together within one and the same extensive catalog. We can think here of the various so-called Common Core projects, or of such notorious transnational legal instruments as UNIDROIT, or of the US restatements, among many others. But all this is to say that functionalism focuses on the results, the outcomes, the effects of legal rules, that is, on the outcomes of the judicial proceedings implementing these rules. In contrast, expressivism focuses not so much on the outcomes as on the arguments that are put forward, the reasoning structures that are typically deployed in judicial proceedings. For it is through the arguments and the reasoning structures that the values underlying legal rules come through. And that is far more interesting to the expressivists than the outcomes of litigation. Now, social values and ideals vary across cultures, unlike the outcomes of judicial proceedings, which in fact tend to converge. So like social values and unlike judicial outcomes, then the arguments and reasoning structures deployed in litigation likewise tend to vary from one legal system to the next. And it is therefore not surprising to see that comparative lawyers who self-identify as expressivists naturally also tend to fall in the culturalist camp, in the camp of comparative lawyers who celebrate legal difference as a source of cultural richness, the very opposite of legal harmonization. They tend to be among those who resist legal harmonization and denounce the Common Core projects, as they do legal transplant initiatives as well. Now, from what I just said, we can see right away that functionalism and expressivism presuppose very different conceptions of law. Underlying functionalism is an instrumental view of law, law as a tool constructed for the purpose of producing particular desired social outcomes, law as social engineering. Whereas expressivism instead harbors a view of law as inherently valuable, law as a collective statement of values, as a statement of the values that a particular society holds dear and commits to governing itself by. On the expressivist conception, then, law stands for the kind of society that we aspire to, much more than anything we might in fact manage to achieve through it. Law would be more about who we want to be than about who we are in fact. So two very different, in many ways antithetical views of law. The first consequentialist, the second deontological. I should clarify, however, that that is not to say that expressivists claim that law is entirely devoid of instrumental value. They do acknowledge that law plays at least some role in resolving social problems. Only they insist that that is not law's only or even main dimension. In their view, the expressivist dimension of law, the fact that it states loud and clear and publicly what we stand for as a society, that dimension of law just happens to be far more important than its consequentialist dimension, than its bringing about socially desirable outcomes. Now, one should not assume, for that matter, that these different analytic frameworks necessarily entail fundamental differences in methodology. Methodological differences there are, but perhaps not quite as drastic as one might expect at first. And that is so because any kind of legal study, I would argue, necessarily begins with functionalism. That is, even expressivist comparative legal studies, even comparative legal studies ultimately aimed at unearthing and comparing the different kinds of collective commitments, the different social values and ideals that animate the law of different nations, even those studies must start with some sort of data gathering, right? They first need to identify for each legal system included in their study the legal materials that are to be considered representative or expressive of that system. The materials that can therefore be pieced together into an overall legal cultural narrative that can properly be considered peculiar to that system. A narrative that can properly be considered as embodying that system's exceptionalism, as we call it in comparative law. Once that is done, it does become possible to compare the various narratives among themselves through what is known as macro comparison or system to system comparison. But beforehand, the basic data must be gathered. And any kind of sound comparative data gathering exercise cannot but proceed functionalistically. That is, it cannot but proceed by reference to what is common to the various rules under comparison, to their function, their same or common function in all legal systems. More concretely, that means starting off with a fact scenario rather than a legal label, with the kind of fact scenarios that are submitted to judges on a daily basis. Fact scenarios in the rough, fact scenarios that have yet to be classified as pertaining to torts, contracts, competition law, criminal law, or any and all other legal domains. So something like one individual loses money as a result of another launching an illegal strike, or one individual failing to honor their promise to do someone else a favor. These are neutral factual questions that do not predetermine particular, at least at the outset, do not predetermine particular legal labels or classifications, and therefore can act as neutral starting points for a comparison. Therefore can act as objective tertium comparationis for the purpose of pinpointing the differently labeled and classified legal notions bearing on them in different legal systems. In contrast, starting off with a particular legal notion, say contract or tort or mens rea, is bound to lead to the comparative exercise astray. It's bound to cause the comparison to not be properly balanced because these labels mean different things in the different systems under comparison. In short, and this is a point that's widely acknowledged among comparative law theorists, insofar as the meaning that is attached to legal concepts such as contract, tort, or property, insofar as that meaning varies across legal systems, that variance is very much part of what the comparison aims to investigate. And for that reason, such concepts cannot provide a neutral starting point for that very investigation. Quite simply, sound scientific method requires that the endogenous object of investigation be conceptually distinct from the exogenous parameters framing that investigation. Of course, once the pool of relevant data, the pool of relevant legal materials for each system, once that pool has been identified, different kinds of comparative lawyers will want to do different things with them. As explained, whereas all self-proclaimed functionalists will want to emphasize the common function that these materials discharge across legal systems, causing the gradual convergence of these systems eventually. On the other hand, self-identifying expressivists instead will want to underscore the different cultural narratives that emerge from these materials, these sets of materials. Yet their methodological starting point remains one and the same. So in that sense, and this is the upshot of my remarks today, in that sense, the deep conceptual and analytic differences lying between functionalism and expressivism in fact belie methodologies that are not so different. Thank you.
Thank you, Professor Falk, for those profound and very penetrating observations with reference to the modus operandi of comparative law from a very functional, relative, and as well as a structural viewpoint. So you had tried to underscore the relevance of understanding comparative law, not only from an epistemological theoretical perspective, but also a perspective which actually lets a person know the nuances of comparative law using an internal approach. So rightly so, you have discerned between the internal and the external approaches, and you have invoked the functionalist and the expressivist perspectives in order to underscore the relevance of comparative law, focusing on the social engineering part, when you have focused on the functional part as well as the cultural differentiation part, which is of course very much relevant in developing society like ours. And a very thoughtful and a very thought-provoking presentation indeed. We have with us the last speaker of the day of this keynote session, Professor Ola Luukkonen, who is a professor in the Faculty of Law, University of Helsinki, Finland. Now, to speak about Professor Luukkonen, she is the director of in the University of Helsinki. She's the director of the Chinese and the Center for Chinese Law and Chinese Legal Culture. She was, in fact, till 2022, and she has been instrumental in working on a major research project titled "Managing the Social Dimension of Globalization from the Point of View of Cross-Border Restructuring and Services." She has been a holder of several scientific positions of trust and has been a member of the Scientific Council, University of Helsinki, and she has been a member of international research projects in the field of international and European Union labor law. Apart from that, she has quite a few publications in her credit in the field of labor law, transnational law, and of course, private international law, including books, 9 international co-edited books and publications in other peer-reviewed journals. In 2002, she was invited to give the Reçu de Q lecture by the Hague Academy of International Law. Over to you, Madam Professor Luukkonen, please.
Thank you so much. Good afternoon from Helsinki. I am happy to speak to you today, and I'm grateful for this great opportunity to attend this wonderful event and offer my contribution. So I will discuss comparative labor law, starting from the limitations of this field and ending to an attempt of a kind to build a picture of opportunities this field can offer when dealing with the challenges of working life, either domestically or beyond state borders. Comparative labor law has been a neglected discipline. The explanation appears to lie in the highlighted domestic nature of labor law, but also in well-known difficulties that entering into the foreign domain through comparative efforts entails. So comparative labor law has, over the years, maintained a very specific and small field which traditionally emphasizes differences between different labor law systems. It is often considered limited and nation-state oriented, as well as quite technical by nature. So it is often thought that the task of the researcher doing comparisons is to have a good command of his or her own labor law system, labor law model, and industrial relations within his or her own country, and then to just share this knowledge with others. Accordingly, it is thought that at most, really relevant information can be provided on the differences and similarities between two or more national systems which are close enough to each other. Although comparative labor law has a certain conceptual framework which it uses, there is a lot of variation in the meaning contents attached to even basic concepts of labor law. We tend to claim that labor law is a very culture-bound field. When doing this, we may recall the words of a famous comparatist, Otto Kahn-Freund, who emphasized that in collective labor law, culture and society and its power relations play such a key role that legal transfers or transplants are not really possible. So there is a heritage of highlighting that all labor law models have to be viewed in their context, that they have often been shaped through a complex and unique historical, socio-economic and political development. There is a grain of truth in all caution. Comparing legal systems rooted in similar cultural traditions and operating in similar socio-economic conditions is easier and safer, and greatly differs from a comparison of systems which derive profoundly from different legal cultures and traditions. Now, what I would like to do today is to problemize these old premises a bit and question their adequacy in the global world of work. My claim is that we should better understand that the framework of labor law has changed. In our era, awareness of the issues of working life that are important to sustainable development and for the mindset of the UN Agenda 2030 has spread around the world. There is a growing need for communication between different kinds of labor law models, and this is a global need for communication. Challenges that we face when sustainable labor governance is considered make us look at labor law differently than before, differently from the past, because the operating environment of labor law has changed so significantly. I would argue that comparative labor law needs to be renewed in order to use it to look at global as well as transnational legal developments in a more fruitful and perhaps also in a more holistic way. I believe that a certain renewal of comparative labor law would benefit not only comparative labor law itself, but also labor law, as the labor law systems of different countries struggle with new kinds of challenges. However, I do not want to talk only about the instrumental value of doing comparisons, but about comparison as an exercise, as an activity that can contribute to promoting social sustainability. In legal comparison is also seen that when we concretize sustainable development objectives, this can also be linked to workers' fundamental labor rights, and we can also use comparative efforts in this exercise. So my main arguments relate to three different aspects, which I will next seek to discuss. First of all, I think that comparative labor law must come to the fore. Comparative labor law often takes a backseat in labor law research, and this, I believe, has to end. It is also possible that comparative labor law is mirrored against the development of substantive labor law itself, so that one emphasizes comparisons made while adhering to the conceptions of traditional labor law. Moreover, functional legal comparison is often the mainstream, and it is practiced largely with a functionalist mindset lacking in-depth research inquiry. I do not mean that traditional comparative methodology would not have place in the field of comparative labor law. Quite the opposite. I think it is the practicality of traditional methodology and the ways in which it can serve practical knowledge interests that bring researchers seeking to develop their own labor law systems to the field of legal comparison, and that is a value as such. But comparative labor law should involve something more. It should be able to join the debate on labor law and its achievements so that comparative law's profound ideas and the range of methods and possibilities that comparative law offers are involved. Comparative law rightly involves pluralism in terms of methodologies and approaches to law. When it does so, it clearly invites comparatists to use comparisons in rich ways. This means we should not see comparative labor law only as a side method of legal work or research. It deserves to be treated as a field which can produce fresh insights to our understanding of the world of work and the roles labor law plays there. Actually, my second point relates to this. I think that comparative labor law should help labor law in its struggle to achieve a better self-understanding. What I mean is that comparative labor law could perhaps be placed in the context of the debate on the ultimate purpose of labor law. This involves the need for labor law to better understand its own role so that labor law considerations can continue to be at the heart of research of working life issues, so that labor law maintains its capability to identify current challenges and search solutions to them. Comparisons can contribute to identifying challenges to labor law, to anticipating changes in the labor market and the economy, and to developing solutions that would meet these challenges. In fact, the task of developing labor law's self-understanding has proven a difficult one because, as said, labor law is very much of a national character, and labor law research, even in a global perspective, tends to emphasize differences and specificities in quite simplifying manners, actually. At the same time, however, it is largely admitted that labor law has confronted problems and challenges from many directions that challenge traditional models of regulation. Many of these challenges cross state borders. It is clear that labor law can't be seen in terms of the regulatory needs of one traditional form of work anymore, but it has to be able to understand atypical work and the diversification of working life, paid work, self-employment, and various forms in between. Work in the informal sector must also be taken into account. Work is done in different conditions, and we should see that many problems are common to different systems. I believe that the objective of labor law to protect those who work and to promote social justice requires a better understanding of what kind of weaker parties exist in working life and what we mean by decent work. Comparative law can help to refine the classifications and develop the understanding needed when the components of protection or lack thereof are put together. Importantly, comparisons may make us look more closely and more critically at the boundary between protection and its absence. Entering into new domains through legal comparison requires a mindset which does not overlook the question of contextuality. Law as a social phenomenon is deeply embedded in the culture and traditions of a particular community. Yet, I believe comparatists tend to focus on the normative structures and systems and remain at the surface of the legal system, treating any extra legal, cultural, as well as social factors as irrelevant or something to overcome. Traditional formalism, if I may say so, is poorly suited to the growing need to understand new legal developments that are not tied to nation states. This brings us to the fact that developments of globalization have lowered the boundaries between states and regions, and the discourse of methods of legal comparison has received new tones supporting pluralism and calling for respect for the otherness. Thirdly, my third argument would be that comparative labor law must take on a new role and new approach in the face of global challenges that labor law models are confronting and that cross state borders. It should enter the debate which asks for a vision of what kind of labor law we should have from a transnational perspective when we confront massive labor migration or cross-border work in global value chains. So I would link globalization, cross-border work, and comparative labor law efforts to each other, and do it so that our efforts to understand the world of work are linked to global trends of economic and social governance. New forms of work and different patterns of work challenge traditional regulation also beyond state borders. Globalization challenges the old thinking of the centrality of states and public international organizations as regulators, and it draws our attention to private regulatory actors. Growingly, private actors such as multinational enterprises or private financing organizations play a key role in transnational settings where workers' protection has to be sought outside the traditional state-based regulatory frameworks. For comparative labor law, this means that we are entering a legal environment where we have to move towards a more contextual understanding of law in a transnational legal environment. Although each labor law model bears its own research tradition where changes are conceptualized in different ways, comparative labor law can probably be used as a kind of bridge between state laws and non-state law in search for a broader picture of transnational law. But although global developments have put comparative law aspirations to a broader context, they do not let us depart from local circumstances. Beyond the differences, the aim should be to see also variations in cultural understandings of work and its meaning to individual workers, because this is what labor law and social justice is really all about too. Let me now briefly turn to the question of fundamental labor rights that form a central yardstick or analytical framework in terms of social justice and decent work. In 1998, a key milestone was reached when the International Labour Organization ILO adopted a declaration affirming the fundamental rights of workers. Last year, the declaration was supplemented so that occupational safety and health were included in the list of fundamental labor rights, which already included the abolition of child labor, the elimination of forced and compulsory labor, the elimination of discrimination in respect of employment and occupation, and freedom of association and the effective recognition of the right to collective bargaining. Huge amount of workers worldwide are in vulnerable working conditions. One of the ILO's key objectives is to get countries to ratify the core conventions behind these fundamental labor rights. This kind of work is a long-term process. It can be furthered through legal comparison by developing the methodology of comparative labor law further so that it could identify the key features of different labor law systems and their legal cultural elements in a more sensitive and nuanced way. Some years ago, my colleagues and I investigated the implementation of fundamental labor rights in China. We soon realized that we need a broad approach to law, allowing more space for cultural dimensions and seeking to understand them in the context of the legal practices. We noticed that we have to see beyond the dichotomies often used when international treaties and their influence are assessed. We can't therefore only look at the level of legislation, nor can we look at whether or not the ILO conventions have been ratified. We have to go somehow much deeper, much wider, to move at the level of various legal actors and to be able to identify the key players of the legal environment as well as their interplay. So we learned that if we want to achieve better protection of fundamental labor rights, it is not enough to focus solely on a ratification-centered approach. Rather, a view is needed which acknowledges the relevance of various institutions, actors, and approaches that enhance labor rights protection and broaden the spectrum of regulatory mechanisms that play a role in institutional and legal environments where labor rights are dealt with. So this was an important outcome, actually, of our research that we ended up discussing the methodology of comparative labor law in Chinese context, which we thought also put forward experience which is relevant even globally. We learned that comparative labor law allows us to better identify the reasons why ILO conventions on fundamental rights have not yet been ratified, what kind of obstacles countries face, and what kind of development has already taken place before the ratification considerations, development which can only be identified if we look into both law in books and law in action. Let me add that questions of fundamental workers' rights increasingly also arise in transnational situations. If legal comparison plays a new role in the global context for workers' fundamental rights, this means also grasping new regulatory environments and seeking responses to transnational regulatory needs. So developments in transnational labor governance and private ordering should be fully taken into account in the field of labor law and in the field of comparative labor law. They affect cross-border work, labor migration, and global supply chains in multiple ways. This again requires a broader perspective on comparative labor law and its opportunities. Thank you so much for your attention.
Thank you, Professor Yukinen, for your profound and insightful observations with reference to comparative labor law. And you have rightly underscored the tension that lies in international labor law, especially focusing on comparative labor law, and how international comparative labor law needs to be more nuanced and needs to be culturally relative, and so that it may actually buttress the rights of the workers around the world. So rightly so, and you have also referred to your study that your experiment or your investigation that was done on Chinese labor, and it actually leads us to only one thing, to only one conclusion, that we are still a long way to go in terms of international labor law, and international labor law on a comparative note has to be more nuanced in order to have the effects of law felt. With this, actually, I throw open this keynote session to any questions or observations, including observations by the esteemed panelists who are here today with us, who have illuminated us with their views and observations. So the floor is open for questions now, and post this we will move to the citation in honor. But right now, any questions or observations from any of the listeners? If there are no questions, if I may be allowed as a session moderator, if the esteemed panelists would allow, then I have at least one or two questions. One question to Professor Yukinen. if she kindly allows me to ask, please.
Yes, my pleasure.
Ma'am, actually, I also personally I also believe that you know, a lot of it has to be done in terms of international labor law revamping, putting it on a comparative context, taking the issues of cultural relativism. But how do you see the role of International Labour Organization? Because seemingly the International Labour Organization has not lived up to the standards of the global populace, the global labor populace. So how do you look at the role of the ILO, please?
Well, actually, I do think that the International Labour Organization confronts a huge amount of challenges at the moment. There's also this issue of the employer side questioning the practice of the supervisory organs when it comes to the right to strike and other profound issues. So I would say that if we think about the future of the ILO, the crucial issue is how the tripartite principle will maintain and function. And now it has been clearly put into a great test. But when it comes to the fundamental labor rights implementation, I would like to just briefly add that what I didn't mention in my presentation, because I didn't have time to do so, is how greatly I value the technical assistance of the ILO offered to individual member states when they try to develop their labor standards to meet the requirements of the ILO standards. So when I did this fieldwork in China, I noticed that the ILO office has somehow been able to work in a way which is constructive and which has been taken largely into account by those officials who prepare new labor legislation and discuss visions for the future. And this is something, I think, if it goes well, this is something which doesn't get much visibility and attention, but it is in the background, and it somehow keeps the things moving little by little. So there are different ways to look into this question you raised. It's absolutely, of course, a fundamental question, but we can have only different perspectives, and we have to just wait and see how the ILO and its tripartite structure will survive the times of turbulence. Thank you.
Thank you so much, Professor. I have another question. If Professor Busani would likely be obliged to answer this. Professor, you had said that unofficial, many of the legal systems do not tend to recognize unofficial laws. Possibly the thrust was on the civil law system. The laws are so stated that the sublime, they go into the sublime. So how unofficial laws, can there be a legal mechanism to actually make the unofficial voices official?
Thank you very much for your question. That I'm not sure having fully understood. You were asking me how an official law can come to terms with with official law. That was the gist of your question. Yeah. Okay. First, a refinement. I was not saying that official legal systems do not recognize an official law. Official legal systems do their job. They are what they are. I was stressing the overlooking by legal scholars of different legal dimensions which live and flourish wherever in the West and outside the West, outside the official legal system. Being that said, and making short what could be a long story, I think that, and field studies show that, unofficial laws impact upon official legal systems in forging, shaping them along the time, and vice versa. So there is a coexistence of different legal dimensions which can be visible wherever. And my point is that comparative law scholars, especially comparative law scholars, tend to overlook.
You're on the way to Franco Manca Holborn. You'll arrive by 12:27 p.m.
I don't think it was addressing me, right? This interference. Was it?
I'm
No.
sorry, Professor. There was some sound.
Okay.
Sorry, extreme apology.
So I think that, I mean, there would be a lot to say in connection with your kind and very appreciated question with what Professor Barker said about different methodologies approaching comparative law. But this is probably not the place to carry along this kind of conversation. My point is that, yes, there is a coexistence and a contamination between legal dimensions. If this does the trick, I don't know if this meets your question.
Thank you, Professor. For Professor Deskoska, I have something to ask, if I may be allowed.
Yes, of course.
Professor, you have referred to the Venice Commission, and you have referred rightly that the Venice Commission is actually striving to consolidate judicial governance, especially in the appointment of judges. Now, how can the good work that is being done by the Venice Commission be replicated across the European the countries, as well as how it may be transplanted in the non-European countries? Because this is something we are also grappling with the same situation in India, that who shall appoint the judges. And so we have the for judges transfers case, we had the NJC Act being struck down in 2015. So there is a lot of hue and cry with reference to judicial appointments, and who shall appoint is a pristine question facing all of us. So given the circumstances, what would be your take on this matter? Thank you.
Venice Commission is open for demands for opinions from every country, not only for the members of Council of Europe or European continent. We received demands from Lebanon, from other countries, from some countries from Asia. So we have given opinions on Mongolia. So everybody who wants to improve the legislation in line with the European standards or higher European standards, they can demand opinions. So the Venice Commission reviewed the proposed law or the legislation that is already in force, and gives recommendation for improvement of the legislation in line with the European standards. We use in the field of judiciary and appointment of judiciary, we use also the case law of the European Court of Human Rights as the Article 6 for fair trial as reference, and also the opinions of CEPEJ, which is International Organization for Judiciary. So each country willing to improve the legislation are welcomed to cooperate with the Venice Commission, and we're also willing to give our opinion. Thank you.
If I may be allowed by Professor Catherine Valk, I would like to ask a question. Shall I, ma'am?
Yeah, yes, of course, yes, absolutely.
Ma'am, you have referred to the to an epistemological, you've tried to provide an epistemology as well as a cognitive interpretation of both functionalism and expressivism. And so how is if we are to understand, we are to apply an a priori generalizability, if we are to sort of use our a priori understanding of comparative laws. So whether you're a common man with a common reasoning, whether the common man would take the functionalist view or the expressivist view?
I don't know that I can answer that. In the sense that it depends on what that common man wants to do with the comparative data. So is this person interested in understanding the various values that underlie legal system, or is this person interested in working, for example, on the harmonization of different legal systems? So that's why when I started off, is it all depends on what the objective is that is being pursued, and I think it's just really important to make clear what is the objective, because depending on the objective, the method will be different.
Yeah, ma'am, sorry to intervene and disturb. Just for example, if it is a lawmaker's perspective, so if a lawmaker in a state like in a country like India, the parliamentarians or the state legislators, for example, if they wish to come up with a law on a comparative note, so what position? So shall they take the social engineering line, or shall they take the expressivist line?
Well, I think they could probably benefit from both, in a way. That is, that the legislator will want to first identify what are the counterpart legal materials to the particular law that they're contemplating enacting. So look at the various legal systems of what has been done in these other systems on that particular issue. Inevitably, they will have to start, as I suggested, through a functionalist starting point, that is asking what is the particular problem, the particular question that they're hoping to answer through that legislation. Once they have identified that question, they can go in the different system, pose that very same question, and ask themselves or ask local legal actors what their judges, what kind of materials would their judges look to answer that particular social problem. And that will give them a number of help them identify the pool of materials that they could possibly use themselves. But then they will have to choose. They'll have to figure out which is the right set of materials that they might want to borrow from, and I think that at that point, this is where the remarks of Professor Liukunen become relevant. Then they have to make sure that whatever legal materials seem interesting to them happens to fit with their own national narrative, or if it doesn't fit, it's very deliberate. That is, they want to move their national narrative in a new direction. If they're somehow dissatisfied with what it is that their old system seems to be standing for at that point, then they have to, then they can do that with the new sets of materials. But it has to be very consciously and reflected upon, and to make sure that the values that underlie these other foreign sets of legal materials fit within or are compatible with what it is that they want to do locally.
So kind of you, Professor. I have my last question to Dr. Satrivan, if I may be allowed. Professor Satrivan is allowed? Is there?
I believe he is not here.
Okay. So I would request Dr. Jane Iyer Matthew, who has been instrumental in organizing another person who has been instrumental in organizing this grand conference, and having me also, of course, in this grand, in an esteemed panel of wonderful academicians and industry experts. So I would request her to read the citation in honor of the esteemed panelists, please.
Sure. We'd like to bestow our gratitude and honor our guests who has been a part of our International Conference on Comparative Law 2024. I don't know, it is odd times for some, at an odd time that we have kept the conference. And in spite of that, all our panelists were there on time and they have been there all throughout. So as a token of our gratitude, I would like to read out citations for each and every one of our panelists. First, I would start with Professor Moro. This citation is presented to Professor Moro Busani in the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Professor Busani, a prominent scholar of constitutional law, is an academician par excellence. Professor Busani's in-depth knowledge on constitutional law and his zeal for making the legal academia more diverse and inclusive is evident from his motivating words. We are highly obliged to Professor Busani for his presence and a thought-provoking discourse. We hereby recognize the contribution made by Professor Busani and express our deep sense of gratitude to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
If I may.
Yes, sure.
Thank you very much. This is much beyond my merits, but my only refinement is that I do not ignore constitutional law, but I think that comparative law could be a good replacement to constitutional law in this wonderful citation. Thank you very much.
Sure. Okay. Thank you so much, sir. Next, we have the citation for Professor Catherine. The citation is presented to Professor Catherine Valka in the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Professor Valka is a distinguished academician with several accolades to her credit for her exceptional contribution in the area of comparative law. An erudite personality with vast knowledge and experience, Professor Valka has immensely contributed in this conference by her thought-provoking words. We are thankful to Professor Valka for her invaluable discourse and taking time to be a part of this conference. We hereby recognize the contribution made by Professor Valka and extend our heartfelt gratitude to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
Thank you very much for that. It is my honor.
Yeah, thank you so much. This citation is presented to Professor Renata Descosa in the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Professor Descosa is a renowned personality in academia and political life. with her area of expertise being constitutional law. Her exceptional knowledge on the matters of law is phenomenal, and her writings are awe-inspiring and thought-provoking. We are thankful to Professor Deskowska for investing her valuable time and enlightening us with her words of wisdom. We hereby recognize the contribution made by Professor Deskowska and extend our sincere thanks to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
Thank you very much. It was my pleasure and honor being with you today. Thank you very much.
Thank you. Thank you. The citation is presented to Professor Dr. Shaileshan Hadley in the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Professor Hadley has an in-depth knowledge in the field of arbitration and mediation and has added immense value in this conference. An academician with experience in teaching and practice as an academician with experience in teaching and practice was instrumental in changing the course of education through his innovative techniques. We are deeply indebted to Professor Hadley for sparing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Professor Hadley and express our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. The citation is presented to Professor Ulla Lukunin in the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Professor Lukunin is a legal scholar with acumen specializing in comparative labor law. Professor Lukunin's in-depth knowledge and zeal for imparting knowledge is unparalleled. We extend our sincere thanks to Professor Lukunin for sparing her precious time and adding value to this conference. We hereby recognize the contribution made by Professor Lukunin and extend our sincere thanks to her. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia.
Thank you. Thank you so much for this honor. I am most grateful for your kind words. Thank you.
Thank you so much. The citation is presented to Ivan Satryavan in the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Dr. Ivan's prowess is in the area of constitutional law and its various facets. A dynamic professional with generous knowledge and passion, he has made a significant contribution to this conference. We extend our sincere thanks to Dr. Ivan for sparing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Dr. Ivan and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. This citation is presented to Mr. Hemang Shah in the keynote speaker session of the International Conference on Comparative Law on Friday, the 9th day of February 2024. Mr. Shah is a stalwart in the field of startups, IT, and IP, an illustrious personality with profuse knowledge and enthusiasm towards innovation, IP, and tech transfer. Mr. Shah has contributed immensely to this conference with his insightful and inspiring words. We extend our sincere thanks to Mr. Shah for sparing his valuable time and enlightening us with his words of wisdom. We hereby recognize the contribution made by Mr. Shah and extend our sincere thanks to him. Presented by Amity Law School, Noida, Amity University, Uttar Pradesh, and School of Business and Law, Edith Cowan University, Western Australia. Thank you so much, one and all, for coming and gracing this occasion and imparting your knowledge to us, being academicians and students who have gained a lot from your discourse. Thank you so much. Rajat sir, you can continue with your vote of thanks.
Thank you so much, madam, for reading out the citations of honor. It is always difficult to wind up such a wonderful session. We have heard so many esteemed panelists today, and we have heard on a very nuanced and on a very positive note, and we have also learned how we can take the positive law forward. I mean to say how we can take the law forward. I'm sorry to say positive law. How we can take the law forward, the international comparative law forward through a conference like this. So to begin with a vote of thanks, let me first start with the esteemed panelists of today. Professor Mauro Busani, Professor, University of Tri-State Lee, and then followed by Professor Renata Deskoska, Professor, Stunius Primus, Macedonia, Mr. Himansha, Director of Engineering, Qualcomm India Private Limited, Bengaluru, Dr. Iwan Satriawan, Professor, University of Muhammadiyah, Yogyakarta, Indonesia, Professor Dr. Shailesh Hadley, Registrar, Dharmashastra National Law, University Jabalpur, Professor Catherine Valk, Professor, University of Toronto, Canada, Professor Ulla Lukinen, Professor, Faculty of Law, University of Helsinki, Finland. Without your kind presence, this keynote session would have been infructuous, would not have been possible. So a heartfelt thanks to all of you. Secondly, I would like to extend my vote of thanks to the Chancellor of this university, because without whom this international comparative law conference wouldn't have been possible. So my heartfelt thanks to the Chancellor, to the Honorable Vice Chancellor, to the Honorable Chairman, to the joint HOI, to the head of the institutions and the joint directors, to the faculty members of Amity Law School, Noida, especially Dr. Rupender Singh and Dr. J. Nair Matthew, who have worked tirelessly round the clock to make the international conference possible. And my vote of thanks to all the faculty members of Amity Law School, Noida, to the organizers of the Business and Law, Edith Cowan University, and all the professors who have come here and who have joined both online and offline in this keynote session too. And last but not least, all the students, the staff members who have played an instrumental role in making this conference a live reality. So wonderful to have you all here. With this note, with this vote of thanks, I formally wind up this session. Thank you so much.
I also like to thank to a wonderful session moderator, to Dr. Rajat Banerjee, that he has wonderfully managed the entire keynote session. So thank you very much. We are highly happy to have you on board of ICCL 2024. Thank you very much, all the professors across the globe. Thank you.
Thank you.
Thank you so much. Thank you.
Thank you.
Hopefully we'll meet next time.
Thank you and bye-bye.
Thank you. Thank you so much. Bye. Bye.
Bye, everyone.
Thanks
Thank
to you.
Yes.
Bye-bye.
IT
Session
support
can
may
be
close the
closed.
team.